Good morning, Mrs. Jacobus and everyone.
Good morning, my lady.
Good morning,
Good morning,
Judge.
my lady.
Good morning, Judge.
May it please the court, my lady.
Nelly, can you
Morning.
please call the matter on record?
Thank you, Judge. Today is the 2nd of February 2022, calling the matter of Life Esidimeni Inquest, case number I-001 of 2021. Thank you, Judge.
Thank you. Mrs. Jacobus, you are reminded that you are still under oath.
Yes, my lady.
Mr. Pichela, you may proceed.
As the court pleases, my lady. Ma'am, Mrs. Dorothy Franks will come and testify that she encountered problems on this project because firstly, she was not given the correct patients which were promised to her. What is your comment on that?
I am aware of that, Counsel. With the placement of the first patients, I was present and I've tried to intervene, but I was told there's no other patients to be given from CCRC.
And she will further testify that some of those patients that were given to her were in a state of health at the time when they were transferred to her.
I was notified when she encountered problems with 3 patients, and those are 3 that I've mentioned in my statement. And I would then remove them immediately to Mamelodi Day Hospital. And during that, she also then told me she has also...
Mrs. I'm sorry to interject. You confirm that indeed she received patients which were not of good health.
Yes, my lady, according to my observation with the 3 that she has contacted me.
Yes,
and
you
then
must
she also
listen to the question. Just listen to the question where Counsel wants you to expand, then he will tell you. Yes, thank you.
Okay.
She will further testify that patients that were given to her, some of them did not have their medical history with them. There were no indications of any chronic illnesses that the patients may be suffering from. That the department failed to give her adequate support. In the first instance, with medication and also with financial support. Hence, she had to dip into her own pockets to ensure that those patients are taken care of.
In terms of the medical records, I was told by Mrs. Natlo that when the patients were sent to her that evening, the medical records and medication would follow the following morning, and it will be enough for her to start off with. In terms of, I was regular on CCRC premises, and I've given my best support according to my knowledge. And the third point was in terms of financial, yes, that I'm aware of because they didn't receive a subsidy as yet at that stage.
Yes. We are now going to move on to the testimony of Ms. Karina Morale.
Yes, Counsel.
Ms. Morale will come and testify that between the period of 12 May 2016 and 28 May 2016, she received in total 185 mental health care users.
How
185.
185.
Yes, my lady.
Between the 12th and?
The 12th
12th
and
of May?
28th. 12th and 28th.
Continue.
And this were from Life Esidimeni, Waverley, and Rand West Care Centers. What is your comment on that, ma'am?
I cannot comment anything on that, Council, because I wasn't present or part of the team that down referred patients. And also when she received patients, I wasn't on the premises.
She will testify that the bulk of those patients, although they had referral letters, they only had medication for a period of 21 days, and that medication had expired at the time, that they did not have any identification books, and they had incomplete medical records, which did not detail any chronic conditions, any special dietary requirements, and basically did not give a full indication of the specialized kind of care that the patient would require.
My comment, Council, the medication I'm aware of, because when the administrator from Zepong contacted me, that is how I intervened. I contacted two doctors and one from the admission unit to assist. And the medication was dispensed from Vescopis Pharmacy.
Just before you proceed, the statement, you must listen attentively. Do you disagree or agree with the statement?
I agree with the medication.
That the medication had expired?
Yes, and that is when they contacted me and told me it has expired. And in terms of the medical records, that I cannot attest to, because I've been told that they were given discharge letters and not full medical files was sent down to the district.
So
The
you do confirm that?
Just a second, there is the issue of identification and the fact that the medication that they had was not adequate. It was only for 21 days.
Yes, my lady, I've already answered that. I said when the
No, do you agree? You agree?
Yes, I agree. I agree with
and then
what is
also
said.
with the issue of identification.
Identification in terms of medical records, that I cannot comment on because I wasn't there when they received the patients and the records or discharge letters. I have no knowledge of that.
Continue.
She'll testify that the mental health care users that were given to her were clinically unwell. They appeared dirty and unkempt. They didn't have a change of clothing on them or even shoes at the time that they were handed over to her.
My comment on that, Council, from Tsepong's side, on that stage, I cannot comment. I wasn't there when the patients was received or what they came in with. But it was a general problem at all NGOs that complained about not enough clothing and but unkempt, etc.
Okay. That she will testify that upon receipt of these patients in the state that they were, she took steps to ensure that she checked their high blood pressure and sugar levels. She fed the patients, clothed them without any financial support from the Gauteng Department of Health or any assistance financially.
Yes, that's correct, Council. There was no financial support for the NGOs.
She will testify of an incident which you are aware of that happened on the 1st of September 2016 at the Tsepon Center, where some of the staff went on strike and failed to report for duty because she could not pay their salaries due to lack of funding from the Gauteng Department of Health.
Yes, Council, I've been informed afterwards about it.
Her testimony on this point will be that you were informed of this incident and you even arranged for her to receive additional help from, I think it's Vescopis, which in the form of nurses and staff and so on. What is your comment on that?
Yes, Council, additional help was sourced for all NGOs that encountered problems, but maybe not sufficient staff, but we've tried our best to source staff so that they can receive the help.
She will further testify that she had expected to receive mentally stable patients who were manageable and at the end of their treatment cycle, as she was appointed to be a step-down facility.
Yes, Council, and that is the premise of NGOs that will receive chronic mentally stable patients. That's correct. Sorry, Council, and that was also according to her preference, what type of patients she would like to have.
She will testify that the intake, that the last intake date that she had was the 28th of May, and the project, but the first payment that she received was only in September of 2016. So the period in between, she had to finance the whole project herself.
That's the correct statement, Council, and unfortunately, I cannot attest when the subsidy payment started. The district will have knowledge about that.
She will testify that she was given, initially she signed a service level agreement in April of 2016, which was done between herself and the Gauteng Department of Health. And further that, despite the existence of this service level agreement in April and the terms contained in there with regard to the issues of payment was never made until September.
Council, I cannot say yes to that. In terms of service level agreement is being done between the NGO and the district health officer, the district coordinator, NGO coordinator would have knowledge about that.
Yes. She will further testify that in August, on the 10th of August 2016, she was forced to sign a second service level agreement with the department, and that was the only time that payment was effected. And this second service level agreement had amended terms which were not reflected in the first one. So what would be your comment on that?
I haven't seen the service levels agreement and was not part of it, Council.
Okay. Lastly, she will testify that at the start of the project, when she was being recruited to come and join the project, she was promised that she would be provided with a starter kit, which never came to fruition. Because in a subsequent meeting, she was told that once she became part of the project, she was told that the starter kit did not exist anymore.
Council, if I may, what does the starter kit consist of? I'm not sure about the terminology.
Starter kit would be startup capital to establish a project, I believe. So that is financial support at the initiation of a project. Yes. Okay,
as I've said earlier in my to other council it is asked, years back there was startup funds available for NGOs. But prior to the project, about 3 years or so, that was stopped and it wasn't implemented again. And I think Dr. Manamela applied for startup funds, but apparently it wasn't signed or finalized.
Okay. So testify that despite the existence of the service level agreements and the terms embodied therein with regard to termination of the contract and the requirements for notices, she was not given a 6 months notice before the termination of the contract.
That also, Council, I cannot comment on because I wasn't part of the termination of the process.
And further that the patient was simply removed from her care. There was no court order to authorize such removal of those patients.
I cannot answer on that, Council. I have no knowledge of that.
That concludes my question with regard to Ms. Karina. Sorry. Yes, with regard to Ms. Karina. I'm going to move on now to Ms. Diane Noile. Now, Ms. Diane Noile will come and testify that initially she was appointed as a CEO for Life Disciples International by a Mr. Wagner, who stepped down as CEO in February of 2016.
Council, I have no knowledge about it.
Yes.
And can that be properly, just a second, I don't think that is going to appear properly on record. What is the response? I think there was a dialogue between the two of you.
Oh, I said, my lady, I don't have any knowledge that she was appointed as the CEO for Life Disciples.
Okay, thank you. Proceed.
She will further testify that this Mr. Wagner disappeared without a trace after there was a dispute that arose regarding the signing of a service level agreement between, in fact, it's a lease agreement between LDI, that is Life Disciples International, and the Cullinan Care and Rehabilitation Center.
Thank you, Council. I have no knowledge about that.
She will testify that in April of 2016, she was subsequently appointed as a CEO of Siabadinga. What is your comment on that?
I have no knowledge about that, Council. I wasn't part of that process.
She will further testify that prior to this date, she had no dealings with Siabadinga as a member or as a founder in any capacity other than she facilitated the meeting between Siabadinga and the Gauteng Department of Health when the LDI contract fell through.
I have no knowledge about that, Council.
She will testify that Siabadinga is owned by a certain Ntombile. Siabadinga is owned by a certain Ntombifikile Ndlabantu Mabena, who is based in Ekangala. What is your comment on that?
I have no knowledge about that, Council.
She will testify that in her tenure as CEO, the problems that she encountered, as with the previous ones, is the same problems that patients were handed over, no proper medication was provided, no proper support was given, the patients were clinically unwell, they were unkempt, and she was not informed of any chronic illnesses that were, or any special dietary requirements that the patients might have. And also that she was not given any financial support.
Thank you, Council. I have no knowledge about that.
She will come and also testify about an incident that took place at CCRC, where she was initially allocated wards and they were subsequently taken from her. What is your comment on that?
Yes, that I have knowledge about. There was one ward on my meeting with her that I've seen. And then during my observation on the premises of where the NGOs were located, I've observed a ward. And then on a Saturday morning, Dr. Manamela called me to Cullinan to come and say she wants to discuss a ward with me because she couldn't get a hold of Mr. Tobane. So I went, and when I got there, she alluded to me there's only 7 patients in the one ward, and she needs the ward, and those patients needs to be removed. And that is why I said we cannot.
I'm going to interject again here. I'm sorry. This evidence is on record. Mr. Pihlele is just telling you what this person is going to say.
I acknowledge.
Either agree or disagree. Please.
I agree with that.
Don't repeat the same evidence. We also heard about it yesterday and even prior to that. Thank you.
Thank you, my lady.
And she will testify that this particular incident led to overcrowding of mental users at CCRC, those that were allocated to her.
On that, I cannot comment, Council. I haven't seen the ward and where the patients was in.
She will also testify that she had 72 patients under her care, and that she was required to house them in 2 wards with a maximum capacity of 50 patients. So it's 25 patients per ward. So she had 72 patients, but she was required to house them in a ward that can only take 50 patients, meaning that there is an overflow of about 22 patients.
I have no knowledge about that, Counsel.
And she will testify that despite complaining and asking for assistance was never offered to her with regard to this overflow of patients.
I have no knowledge about that, Counsel.
She will also testify that all of a sudden, on the 8th of July 2016, they received a letter from the Gauteng Department of Health, which stated that
Sorry,
they were
Counsel, can you
operating.
just repeat? I can't hear.
Okay.
Yes.
Saying on the 8th of July 2016, she received a letter from the Gauteng Department of Health, which indicated that they were operating and instructed them to vacate the premises immediately.
Yes, I'm aware of that, Counsel.
Now, this despite the fact that patients were given to her by the same Gauteng Department of Health. What is your comment on that?
Counsel, my comment is I have no knowledge who has placed the patients in Siabadinga's care.
Yes, but you will agree with me that it would not have been possible to give this number of patients to a person without knowledge of who they were and whether they actually are licensed, and also whether they are registered, because CCRC is a state institution. Would you agree?
I have no knowledge about that, Counsel.
Now, she will mention the fact that there was never any service level agreement that was entered into between the Gauteng Department of Health and Siabadinga during the time that she was the CEO of Siabadinga.
I have no knowledge about that, Counsel.
She will testify that she called you on the 1st of May and informed you of her financial situation, and that you referred her to Steve Biko Hospital to fetch beds and any other things that were not being utilized. And she will further testify that
Can she
you
answer?
were aware. That's it, please, my lady.
Thank you, my lady. I have no knowledge about that and that she called me concerning beds.
Thank you. Proceed.
She will testify that you were aware that she was no longer with Life Disciples International, but was now with Siabadinga, operating at the CCRC. So essentially, you knew as early as the 1st of May 2016 that she was no longer with Siabadinga, but no longer with Life Disciples International, but now with Siabadinga.
Were you aware?
No, Counsel, I wasn't aware of the existence of Siabadinga.
She will testify that before she received patients, there was no time where she was officially vetted before the patients were handed over to her.
I have no knowledge about that, Counsel.
She will testify that she started receiving patients from the 5th of May. That were patients that were being transferred from CCRC.
I have no knowledge about that, Counsel.
And that by the 26th of June, she had a total of 72 patients.
I have no knowledge about that, Counsel.
Now, she will also testify that she ran out of medication, and there was a time where some of the patients spent a period of about 2 weeks without receiving any medication, and that these challenges were communicated to the Gauteng Department of Health, in particular to you, Dr. Manamela, and a certain Mr. Pite.
That
Mr.
incident was
A certain Mr.
The Director of Health, Mental Health at Tshwane District, Mr. Pite. I don't know if I'm pronouncing it correctly, my lady.
He would know, you would know the surname, isn't it?
yes.
How
Mr.
do you pronounce that?
Mr. Pitse. P-I-T.
Oh,
Pitse.
Pitsi.
Pitse.
Pitsi.
Pitse. P-I-T-S-I.
Okay, Pitsi. Okay.
Pitse.
What is the response?
That wasn't communicated to me, Counsel. I have no knowledge about that.
She will testify that you advised her to approach the Tshwane Regional Pharmacy for assistance with the provision of prescribed medication. You personally, Ms. Jacobs, will say that you are the one who advised her to approach the Tshwane Regional Pharmacy for assistance with regard to the problem of medication.
No, that's not true, Counsel. I never spoke to her about medication.
And she will testify that on the 1st of July, 2018, yourself, together with Dr. Manamela and Matilda Malaza, brought 3 unidentified patients to her who were from Life Esidimeni. That is the 1st of July, 2018.
Counsel, I have no knowledge about it. I never took patients to Siabadinga.
Now, she will testify that there was an incident in which I just want to make sure, my lady, please bear with me for a second. I just want to be sure of Okay, I think that would sum it up for the testimony of Ms. Diane Noile and what she will come and testify about. We will now move on to Ms. Ethel Jeannie Ngube's testimony and what she's going to say. Am I audible? Because I'm seeing an indication.
Yes, I can hear you, Council. I can hear you now. It's a bit soft, but I can hear.
Okay,
Yes, you're
I'll
well.
try.
Now you have taken the right position. You can continue.
Yeah, now it's a bit better.
Okay. Because, okay.
It's just that you keep on moving. I don't know. Proceed. We'll tell you if we can't hear you.
Okay. As it
That
pleases my
position
lady.
is no longer the same now.
As it pleases my lady. I'm just trying to sort out my documents because there's a lot of them in front of me. Ms. Ethel Ngube will testify that she ran a previous NGO which was catering only for children with severe and profound intellectual disabilities and had been partnering with the Gauteng Department of Health since the year 2010.
That's correct, Council.
She will testify that she had drafted a 5-year plan in which she sought to expand the operations of that NGO to also include adult patients.
Yes,
and
Council.
that this
Yes,
plan was
I'm aware.
submitted to the department.
Yes, Council, I'm aware of that. She has discussed it with me.
Yes. She will also testify about the fact that of that email that we were referring to yesterday, that she got an invitation to come to the meeting where she was introduced to the operations of Life Esidimeni and the fact that you're going to require NGOs and it's going to be closed and so on. So we're not going to dwell much on this. But you may confirm if you feel that it's appropriate.
Yes, Council. As I've said yesterday, the invitation was sent out to the coordinators, and the coordinators indeed invited all NGOs, existing and new ones that they knew of, to the meeting at Veskapis.
We also testify that for this project in particular, she was paired with Ms. Karina Morale of Tsepong because both of them were coming from the same area, that is Atteridgeville.
Can you just repeat that question again, Council, please?
She was paired with Ms. Karina Morale of Tsepong because both of them came from the same area, and that area is Atteridgeville.
I have no knowledge about that, Council.
She will testify that a decision had already been taken that she will be utilizing the old nurses' home at Kalafong Hospital and that she will be receiving about 150 children.
Yes, Council, in terms, sorry, can I answer?
Yes, ma'am.
Oh, thank you. In terms of hospital utilization, there was a general call put out in the meeting by Dr. Manamela to all NGOs because some of them did not have facilities, and 7 people opted to occupy hospital buildings throughout the province. And that is how the Pretoria ones would then utilize the Kalafong Hospital.
So you agree with the statement?
Yes, ma'am.
And further that she will be receiving 150 patients?
Yes, my lady,
Children,
after the
eh?
inspection, yes, according to her criteria that she has put forth, she wanted children.
Okay. So following the fact that Kalafong Hospital was not habitable, she was advised by you at the meeting held in Kalafong that she should look for alternative houses in order that the department should continue with the placement of patients that were already earmarked for the NGOs. What is your comment?
I disagree with that statement. It was quite a long time with the declaration of Kalafong, and when the final report from the DDI unit came that the place cannot be utilized because of structural problems, then they were told to look for alternative accommodation, which she did, and she provided a place with an address to, and we went out and inspected that place, the house in Ettrishville.
And at this stage, it was still, she was still looking for premises that will accommodate 150 children.
I'm not aware of that, Council.
She will testify that initially she had indicated that it will not be possible to get a house that can accommodate 150 patients, children in this instance, and that you indicated to her that it is possible because there are other NGOs that are operating from different houses under one name, and they are being approved as compliant. And that you stressed that she must get houses that will accommodate 150 patients, as no other NGO will carry the burden of receiving patients that had been allocated to her. What is your comment on that?
No, I disagree, my lady.
Continue.
She will detail an incident where yourself, Franz Tobani, and Rochelle Godin met her uncle, Temba Mategula, at Denville with the view of using his house to accommodate a certain number of patients. What is your comment on that?
My comment on that is the first time when I was introduced to the house in Denville, I was called by Dr. Namela on a Saturday morning to go and view the house. And there was already beds in. And then I alluded to them, the beds in the place is not proper beds, but it's bathing beds. The bathing beds was to be utilized at Kalafong for bathing of children, but there were already beds in, and that was the end of it. So that place was never inspected by myself or the engineers.
Continue.
Yes, but the question was not about that. In any event, while you were there, the house was inspected. You indicated it was approved or certified compliant and that it could carry 39 patients.
No, that's not the truth, Council.
She was then issued with a Kalafong license for 150 patients.
Children.
Yes.
Mm-hmm.
Although at that stage, the Kalafong facility had already been declared to be non-compliant.
Yes, I'm aware of that, Council. The 150 Kalafong license was never changed for all the all the prospect occupants for Kalafong. So they moved with that license to the house that we've initially, she gave us the address of for 25 patients.
and that this license stipulated child residential facility, and it was issued even before she could receive an NPO certificate.
I'm not aware of that, Council.
Okay.
Continue.
May I proceed, my lady?
Yes.
Sit, please, the court. She will testify that she attended a meeting in Johannesburg that was being chaired by Dr. Manamela, where she was informed that there's a change of plan with regard to the release of those 550 children, as that project will only be the project for Baneng will only be discharged in 2017. So the parameters of the project were changed at that meeting in Johannesburg.
Yes, Council, there was a lot of, even from the other districts, that was prepared to receive patients from Baneng. And due to the Mr. Masanoge's motivation, the Baneng project was postponed.
Okay. And that it is at that meeting that she was now told that she would request, she was requested to assist with adults that will be coming from Randfontein, the Randfontein facility.
I don't have any knowledge about that, Council.
She will say that she raised concerns regarding the issue of the adult children, as she had already prepared for, adult patients, as she had already prepared for children, and was informed by yourself, Ms. Anna Jacobus, that the adults that she will be receiving will be in the same category and the same level of functioning. So, what is your comment on that?
My comment is that is not true, Council. I've never communicated that to her.
Jesus. Now, instead of receiving these patients, she instead received patients with severe, profound intellectual disabilities, and not the type of patient or the category of patients that she had been promised. What is your comment on that?
Just repeat your question again, Council, please.
Remember, the statement that I put to you initially was that you told her that she will be receiving adult patients who are functional at a functional level. But instead, she received patients with severe, profound intellectual disabilities.
That is not true, Council. I wasn't even a part of the referring team.
So you don't know?
Yes, I don't. I didn't communicate that to her. Never.
She will testify that on the 23rd of June 2016, she received a call from a Salome Mashile from the Gauteng Department of Health, Life Esidimeni, who informed her to come to the facility to fetch patients. And then she called you and you confirmed that patients were ready and that you will send a team to assess the patients upon their arrival at Denville.
No, Council, that is not true. It's not true. I've never done that. I had no communication with any NGO at that stage during the transfers.
Now, she'll testify that on the same date, she received about 22 male patients who each had only one pair of clothing, summary of their files, a container with a toothbrush and a washing rag. The patients were in a dirty state. Some of them were smelling of urine. They were given medication that could only last for 28 days, and that she was not given the entire medical report for the patients. As such, she was not aware if they had any underlying conditions or chronic, what their special dietary requirements might be. And so that was the state of the patients that she received on this
Any
date.
comment? Do you agree or disagree?
I have no knowledge about it,
Okay,
lady.
thank you.
And that at the time when she arrived on site on that day, she gave you a call to inquire, and you indicated that she must just continue to admit those patients.
No, my counsel, that is not true. I never received a call from her or spoke to her.
She will testify that upon taking these patients, she stayed for a period of about 2 weeks with no one from the department coming to assess the patients as promised.
I have no knowledge about placement of patients, counsel.
She will testify that on the 28th of June 2016, she went to Randfontein to fetch a second batch of patients. And there she found 11 male patients that had already been loaded on an EMS buses. And that there was an additional 3 patients who were supposed to go to Rebafeni NGO. What is your comment on that? Because
I
don't
have no
want it
knowledge about that, counsel.
Now, she raised concern about these 3 patients that were supposed to go to Rebafeni. And she was told that they will come. She was told by one Sanelo, Miss Sanelo, that they will come and fetch them from her center.
I have no knowledge about that, counsel.
She will testify that she discovered that most of these patients were psychiatric patients and not the criteria that she was promised. She complained about this fact to Mr. Mahale, was referred to a Dr. Lengwani, and this Dr. Lengwani told her that she should just take the patients and that they will come and assist when the time comes to swap the adults with the children when they are being discharged. What is your comment?
I have no knowledge about that, counsel.
Okay. Much of her testimony on this aspect does not relate to you, so I'm going to pass on that. She will testify about the issue of the second house, because I see that in your testimony you indicate that she had moved in one of your inspections. I think you call it adopt an NGO, that she had moved without informing the department. Are you aware of that incident?
No, counsel.
So you never made allegations to that effect?
Allegations about the movement.
Yeah, that
Yes, I spoke
you
about
went
it,
and
counsel.
inspected one place and only to find that on your second visit that she had moved And indications are that she did not inform anybody.
Yes, Council, we were sent to assist at the center. And myself and Mr. Tobane went to the place that we've inspected and granted that she could utilize. And when we arrived there, we were told she never utilized that place and she has moved to another house. So we went to the second house. And nor myself or Mr. Tobane was informed about the movement of that house.
Yeah, but that second house that you are referring to, did you inspect it?
No, Council, it wasn't inspected.
No, I'm saying at the time when you became aware, isn't it you saying you went and looked and viewed that second house?
No, we didn't view the second house, Council. There was a problem with the patients. And Dr. Manamela said myself and Mr. Tubane to go and assist because she received the complaint. I think Mrs. Anello reported the complaint. And then we went to the first house. We didn't ask for an address because we knew where the NGO was that we've inspected and allocated and granted. When we arrived at that place, we've been told she never made use of that place and she's at another place. And the people at that place showed us where the house was. So we went to the second house. When we arrived there was already patients in the place.
At the second house?
At the second house, yes. In Etrishville.
Yes, I'm saying you were able to look at the second house. You gained access to the second house.
We gained access to the second house.
Yes.
Council, there was already patients in, and there were a problem with the patients. So we were summoned to go and assist with the challenges with the patients. We did not go and do an inspection. Inspection normally will be when there's a request to do an inspection. And by that time, the inspections has long stopped. We've only done inspection on the first house.
I understand you, Mrs. Jacobas. All I'm saying to you is, you indicated in your statement that she moved from one house without informing the department. Yeah?
Yes, Council.
At that stage, were you the one responsible for handling precious angels?
Excuse me, Council?
Were you the one responsible for precious angels?
Only afterwards, Council. At that stage, I think it was Mrs. Anello that was supporting or monitoring precious angels because she was the one who complained a challenge that we should come and assist with.
Which Mrs. Sanello? We've got just a second. We've got two.
No, Neba Sanello.
No, Neba
Sanello, yes, ma'am.
That's the one who had previously testified, ne?
Yes, Council. Yes, she reported the problem there.
So it was not necessary for her to inform you prior to moving. You agree?
No, it was necessary, Council. And
inform you or inform Ms. Sinello because you are not involved with that process.
Council, can I explain the procedure of moving? Before, if a place has been granted to an NGO and checked and agreed upon to be utilized, but if the NGO for one reason or the other wants to move to another second house or different premises, that person needs to inform the department beforehand, before she utilizes the place, so that an inspection can be carried out.
Yeah, but now my client will come and testify that following that inspection, the owner of the property on the first house decided that he's no longer willing to accommodate mental health care users at this place, and that he's going to turn that into a student housing. Hence, there was a need that she should move. What is your comment on that?
I have no knowledge about that, Council.
Yes, and that she did inform the Gauteng Department of Health about the fact that the place that had previously been inspected the lease, she can no longer be able to utilize that place because the owner has changed his mind to her. What is your comment on it?
She did not inform me about the change or the unavailability of the place, Council.
Yes, but you testified that you are not the one who's responsible for Precious Angels. So it was not necessary that she should inform you in particular.
Council, in terms of, I don't know, your question is not really clear in your statement, but in terms of when the patients were placed at these NGOs, we were divided into teams to look after certain NGOs. And Precious Angels says that at that time didn't fall within my responsibility.
But the question
so it
is,
differs from the
exactly what I'm saying to you, that it was not necessary that she speak to you in particular.
Okay. Now I understand. Okay.
Yes.
do you agree
And that
with
is
that?
what I'm putting to you.
Yes, my lady.
Because you are saying she didn't inform the department. So she's saying she informed the department.
No, my lady, I misunderstood.
Okay.
According council has made it clear now she did inform,
Yes.
but not necessarily to me. So
Yes,
I cannot, I have no knowledge about her informing.
She will testify that she received patients from Anchor House who were transported to her without files, and that you, Mrs. Jacobus, confirmed that Anchor will send those files the following day, and that did not happen.
That is not true, council.
And with regard to the second house, she will also testify to the fact that she moved from the first house to the second house prior to her being given patients. So it didn't happen while she had patients in her care. It happened before she could be given patients. What is your comment on that?
I was not aware of the movement, council.
Okay.
Continue. I'm listening.
She also testified that she had not been paid for a period of 3 months. When this project was incepted, when she first took patients under her care, was not paid for a period of 3 months.
Council, I'm not aware of the period, but I know all NGOs had complaints about not being paid. So that is true.
She will testify of the problems that she encountered. Some of them being that medication often had run out. Patients did not have prescriptions to obtain further medication. She had to scrounge around for food to feed the patients. They did not have toiletry or clothing. She had to get nappies on credit. She had to go around seeking for donations. And that all these problems were known to the department, and the department did nothing about them. What is your comment on that?
I have no information about that, council.
Come again?
I don't have any information about that of Precious that was mentioned now.
Now, she'll testify that of an incident which led to an argument between yourself and Dr. Manamela about a certain Miss Virginia Macapella. Do you remember that incident?
No, Counsel.
Yes.
As it pleases, my lady.
My lady, can I just answer that last question? It's not
Yes.
that I don't know the incident, but there was no argument between myself and Dr. Nomela about a patient, Virginia.
Yeah, tell us about that incident.
Excuse me?
What prompted that incident?
I said,
With
Counsel,
Virginia
there was no
Macapella.
argument between myself and Dr. Manamela about the patient, Virginia. I'm not sure
maybe-
it never took place, my side.
No. Let me rephrase that question.
Are you aware of any incident
No, my lady.
that relates to the deceased Virginia Macapella where
No, my
you
lady.
and Dr. Manamela were involved?
No, my lady, I was never involved with an argument with Dr. Manamela about the patient.
But are you listening to my question?
Yes, my lady.
Were
It
you
never
aware?
happened.
Okay.
No, my lady.
I'm not only talking about the argument. I'm saying, were
The
you aware
patient.
of an incident that related to this particular patient, the deceased, where you and Dr. Manamela were involved?
No, my
Which
lady.
relates to Precious Angels? No.
No, my lady.
Okay, continue,
Never.
Mr.
So you are denying?
My counsel, I'm not denying. I'm saying I wasn't involved and I have no knowledge about it, that there was an incident. I have no knowledge and I wasn't part of anything.
As it pleases, my lady. That would conclude my cross-examination.
Thank you very much, Mr. Pichela. Mr. Pina?
My lady, I see that it's 8 past 11 now.
Yes, do you still have questions? Isn't it you have just told me that you are done?
No, from my side, I'm done, my lady.
Yes. Can I check
Yes.
with Mr. Pina? Mr. Pina, where are you?
May it please the court, my lady.
It's
Taking
about
into-
8 minutes past 11. Do we proceed now or do we proceed after the tea break?
My lady, I would request and suggest that we continue after the tea break, my lady.
Oh, all right.
Maybe 11:30 would be suitable, my lady.
Okay.
By venture time.
Thank you very much. It is now 8 minutes past 11. It is we can now take the tea adjournment and resume at 11:30. The witness is warned. Thank you very much.
Thank you, my lady.
May it please the court, my lady.
What pleases, my lady?
this witness? Silence means consent. So it means Mr. Pitlela was the last. Continue, Mr. Pienaar.
May it please the court, my
Yes,
lady.
continue.
I'm indebted to your ladyship. Ms. Jacobus,
Yes, Counsel.
good morning or good day to you. And hopefully, and I trust, the end of the tunnel is in sight. Now, Ms. Jacobus, I'm not going to keep you occupied for a long time. I intend being brief and to the point. There are only a few issues that I want to clear up with regard during re-examination at this stage. I do not expect, please, a long explanation regarding how the system functioned, etc. Are you with me, Ms. Jacobus?
Yes, Counsel.
Now, Ms. Jacobus, just for the sake of completeness, you had serious concerns and reservations about the practicality of Project Marathon. Is that correct?
Yes, Counsel.
And
I cannot hear, Counsel.
sorry, no. Can you hear me now?
Yes, it's better now.
Now, these concerns you had and the reservations you had, did you raise them with your superiors?
Yes, Counsel.
Continue.
And you were appointed as and acted in a capacity as a deputy director in the Gauteng Department of Health. Is that correct?
That's correct, Counsel.
And you had duly appointed superior officials to whom you were subordinate in the Gauteng Department of Health. Is that correct?
That's correct, Counsel.
And the way I understood your evidence, Ms. Jacobus, where you had concerns or reservations regarding Project Marathon, you raised those concerns and those reservations with your superiors to whom you were subordinate.
Yes, Counsel, to my direct supervisor.
Was that Dr. Monamela?
Yes, Counsel.
Did you have, as a deputy director, in your capacity, any authority to approach superiors beyond your direct supervisor?
No, Counsel, there's a line of function. You have to start with your immediate supervisor. And the immediate supervisor will escalate everything up to senior level.
And now, Ms. Jacobus, having raised your concerns or reservations with your supervisor, did you have any reason to believe that such reservations or concerns, if founded, would not be proceeded with to the higher echelons?
I believe so, Counsel.
So you had no reason to believe it won't be done?
Yes, Counsel.
Now, Ms. Jacobus, although you were a deputy director, you were at a stage, and we need not go into that once again, but you were relegated in your duties to a level of sourcing beds, for example.
Yes, Counsel.
So notwithstanding the position that you had been appointed to in the Gauteng Department of Health, you were relegated to a level where your involvement with Project Marathon had been limited by Dr. Manamela to the sourcing of beds, materials, etc.
Yes, Counsel.
And that remained your function until the completion of Project Marathon?
Yes, Counsel.
And keeping in mind that your duties had been relegated in this regard, where you received complaints, were they directed to the officials that were now physically involved in the department with the transfers, etc., and with NGOs?
I'm not aware of that, Counsel.
No, what I'm saying, maybe my question wasn't clear.
I don't think it's clear. Yes, if you can just rephrase.
Please, the court, my lady.
Mr. Watpringle, do you have something? You want to raise something?
Yes, I do, my lady.
Yes.
My lady, I understand that we are not strictly in adversarial proceedings, and I understand that technically the evidence leader led this witness, but my learned friend does represent this witness. And if he's going to put words in her mouth on potentially contentious issues, then the evidence is going to be worth very little. So in my submission, he stands in a position where he may not ask blatantly leading questions as he's been doing. And even when he's got the wrong answer, he's then given the right answer and asked for confirmation, as he did a little while ago. I accept that in that case, the question was probably misunderstood. But I'd ask my learned friend to be vigilant.
I felt that the question was not clear, but thank you for raising this point. Let me deal with it.
Thank you.
Mr. Pina, would you please refrain from putting words into the witness' mouth? Let the witness answer. She's here to give evidence.
Milady, with due respect, I take cognizance of my learned colleague's objection that is raised, but in principle, I agree in re-examination, but we've been informed by more than once in the proceedings, it's still a form of cross-examination, but I will abide, my lady. I agree. Re-examination, a party should not put leading questions, and I would tender my apology for that.
Unless if that is something that was there in her evidence. Isn't it now what you are trying to do is to rubbish what came up during cross-examination? Because this is so-called, it's cross-examination, but it is the so-called re-examination in the sense that you had initially started with the cross-examination of the witness. I'm just worried that you do not leave the witness to give answers on her own.
Lady, I will rephrase my questions. I have no objection, and I appreciate the objection raised by my learned friend.
Okay.
Mr. Watt Pringle, I have no objection to that, my lady.
Thank you. You may proceed
And I
then.
will proceed accordingly. May it please the court, my lady. I've actually lost the track of the last question I wanted to put, my lady.
I had a problem with the question because I said it was not properly.
Yes, my lady, I will. But
Yes.
nonetheless, my lady, I will proceed.
Continue.
Thank you, my lady. Ms. Jacobus.
Yes, Counsel.
Sorry, the question specifically. We've heard your evidence that from time to time problems were raised with you that were being experienced by NGOs. Is that correct?
That's correct, Counsel.
So now, when that happened, let me put it, in all instances where that happened, did you escalate those problems or concerns to your superiors where applicable?
No, Counsel. Only on 3 occasions.
Thank you, Ms. Jacobus. Now, the next issue I want to refer to, or for the sake of clarity, is and just to refresh your mind, from the cross-examination that you've been subjected to during the past past 10 days nearly being in a witness stand, it appears that there was a misconception regarding the status of NGOs. A misconception in this regard, and that it appears they were being regarded as mini hospitals. Could you just explain to the court or clarify to refute any discrepancy or uncertainty in that regard?
Thank you, Counsel. An NGO are being viewed as an environment, a home away from home. Thus, it's not on the standard of a district hospital or mini hospital, nor standard of Life Esidimeni. And mental health care users referred to an NGO should be stable, chronic users that could be managed by people within NGOs.
Am I then correct? Oh, sorry, let me put it this way. So there is no correlation or analogy between an NGO and a hospital or a clinic even?
The correlation there is, Counsel, if one goes to the Act is explicit that treatment given to mental health care users should be continuous on all levels. And that is if a patient is from a specialist hospital, regional hospital, district hospital, clinic level, and then placed in an NGO, the treatment should be continuous for that person and not being interrupted. And in terms of NGOs, what has been put in place to support the treatment and management of users, there is also the NGOs are attached to formal clinics in their area to continue and assist with treatment. The mental health care team, as described in the Act, there's teams in each sub-district at community level, at community health centers or large clinics, and they also attach to the NGO. Hence, when a NGO manager or a user needs support or evaluation or screening for rehabilitation services, They then call the team out and the team will assist. So the treatment is continuous. They ought to, the clinic should have all the necessary medication and stuff. The doctors are available. Many instances with bigger NGOs, the psychiatrists and doctors will even go out to the NGO to support and screen or assist or re-evaluate the patients on a 6-monthly basis. So the treatment is continued.
And Mr. Jacobus, would that re-evaluation be to determine should he, the mental health care user, remain at that NGO or be transferred to a hospital depending on his or her condition?
Yes, my counsel.
Thank you, Mr. Jacobus. Then, Mr. Jacobus, just a further matter I want to refer to, but without necessarily going into detail. We've heard in depth the situation or that developed at Cullinan Care and Rehabilitation Centre and Siabadinga. Can I take you specifically regarding this issue to the investigation you had to conduct into the death that occurred at Siabadinga? Do you recollect that?
Yes, counsel, I do.
How many deaths did you investigate there?
We did not investigate any deaths when we arrived at Siabadinga, and we requested information and some reports. The Siabadinga manager told us that she has informed the hospital CEO and everything was given to the CEO. And Mr. Tobane then made her aware that we need also to receive the documentation, and then the manager said she will get everything and she will send it up to central office.
So except for this exercise, you did not further, or were you further involved in the investigating the deaths that had occurred at Siabadinga?
No, counsel, I wasn't involved.
And Mr. Jacobus, on the same basis, were you involved in the investigation of any of the deaths that had occurred during and subsequent to Project Marathon?
No, counsel, in no investigation throughout Gauteng facilities.
Now, just to return to the incident or when you attended at Siabadinga at CCRC, what was the nature of the welcome you received, Mr. Jacobus?
Counsel, the first inception was, if I put it, it was welcome but not very open. Because during that, it was my first meeting and seeing Siabadinga on the premises. And then the manager alluded, and I've asked for documentation as one would normally do to establish the nature of the NGO. And she told me there's not documentation readily at hand, but she will get that.
Now, Ms. Jacobus, you referred to the initial response on arrival appeared to be, was it friendly, or did it only appear to be friendly?
Appeared to be friendly, I should say, according to my observation.
Did that, the nature of the reception, did that deteriorate?
I should say so, Council, because after that initial meeting, because I was in the area while besides doing the beds, when I receive calls, I will assist all NGOs. And I said to myself, I should be more on the premises to support or see what is going on at Esidimeni. And the following day when I went, the manager wasn't there. It was the supervisor. And then I went again, I introduced myself and I said, I would like to see the ward or see what is going on, and so that we can see how we can assist. Then the supervisor says the manager is not there and I cannot enter, I should come back. And that is what I did. After that, I've tried again, but with no success. And then following that procedure for that week, I then observe, I was around in the area, observe all the activities from outside. I couldn't see inside the ward. I had no idea how many patients or what the ward status looked like. But I observed outside, and what this thing was, because of the antagonist nature of our communication with Esidimeni, I've observed how the workers, what they're doing, how they handle the patients, and I was a bit worried because according to my observation, I could sense that they have no insight in all spheres now to what is going on.
Mr. Pitlela?
Yes, my lady. I don't know if this testimony came before my time, but it appears that we are now talking of an incident that I'm not aware of, and that was not part of the record. Because if it had been, then I would have cross-examined on it and put my client's version to the witness on this aspect. So I don't know if this questioning came before the time when I came on record or what, but then I would require an opportunity to cross-examine this witness on this aspect. May it please you, my lady.
Mr. Pina?
May it please the court, my lady, with all due respect to my learned friend, evidence had been presented in this regard, and if my recollection does not leave me in the lurch, it was right in the initial stages of Ms. Jacobus's evidence, and when cross-examination commenced, my lady. And so therefore it's not a new issue. My learned friend is not entitled to return to cross-examination. This is a matter that had been raised, had been dealt with. All that I'm putting to her in re-examination is to put it into perspective what the attitude was, because Ms. Jacobus has been referred at most of the colleagues to Esidimeni and CCRC, my lady. I'm just putting one single issue that's going to come to the fore with my next question I wanted to put, why I'm referring to this to have it clarified also, my lady.
Mr.
And
Pitlela?
clarity on it. May it please the court, my lady.
My lady, the point that I'm making, and which my learned colleague seems to be missing, is that I was not part of the proceedings when that question was put to the witness. Hence, I'm saying I did not get the opportunity to cross-examine the witness on that aspect. And will I then be given an opportunity to cross-examine the witness so that I can explore that aspect?
Yes, even then, but is the information not on record? Because that evidence is there. It was there at the beginning of the witness cross-examination. Maybe you could have missed it, but that is what I'm. Can I hear someone, Mr. Van Bergen?
Thank you, my lady. If I may be of assistance, my recollection is that the incident that is being referred to was dealt with in quite a bit of detail in the second affidavit, H2 of Ms. Jacob. So
Mr.
it
Pitlela,
formed part of the record.
That is why it's something that is contained in the witness statement H2. So the evidence is on record. Mr. Pinar, do you want to say something before I close this?
Lady, I would just like to, I agree with Mr. van Bergen. That is the case, my lady. And Mr. Pitlela, with all due respect to my learned colleague, when he came on board, if I can refer to it as such, he had the opportunity to at least peruse the evidence being presented by Ms. Jacobus. He was given the opportunity to avail himself of, if he desired a need for further time, to avail himself thereof, which he accepted but decided he's ready to continue, my lady. And therefore, I trust, my lady, and I believe, and I would submit, he's had ample opportunity to peruse the evidence, and the evidence has been presented. And unfortunately, if he deemed it not of importance to avail himself of that opportunity, my lady, then he's bound. He's the author of his own demise, if I can call it that, in this aspect, my lady. And therefore, I would submit I'm entitled, and the witness is entitled to proceed and with a re-examination, my lady.
Are you coming back, Mr. Pitlela? Yes, let's hear.
My lady, I take issue with the final part of the statement made by my learned colleague. Now, when I agreed to come on record in this matter, I did indicate to the Honorable Court that there is 37,000 documents.
Correct, yes,
which I'm required to go through. Now, I understood the feeling of the court and Mr. Late to be that it will not be a problem for me to come on record at that stage. Now, the witness had already been sworn and had already testified. Now, we are at a stage where issues are being referred to which transpired before I came on record. And I'm being told now that I'm the author of my own misfortune and all those kind of things, which I find very, very objectionable. Because, my lady, if it would have been ideal for me to have been granted an opportunity of at least a period of 6 months, that this proceeding should hold for a period of 6 months in order to allow me an opportunity to acquaint myself with the entire record. And I would then request that after this re-examination is presented, I would request a postponement for that period so that I cannot be the author of my own.
For a period of 6 months?
Yes, my lady, because I believe that at a humanly rate of 8 hours per day, reading documents every day, 37,000 pages, having to print, having to carry, having to store, that period is reasonable. So I'm going to request a postponement of this matter for a period of 6 months after this re-examination is done, so that I can acquaint myself with the record and properly take instructions, because clearly I do not have sufficient instructions to allow me to continue further with these proceedings.
Can we first deal with this matter? Let's not mix issues. If you want to do that, if you want to make that application, you will do that. For now, let me deal with this issue that you have raised. This issue, it's not a new issue in the proceedings. I sympathize with Mr. Pitlela, because even when he started, I indicated to him that he can take his time before he cross-examine all the witnesses, taking into account that he has just came on record. He has just come on record, but I cannot disallow the line of questioning, because this was fully canvassed with the witness, and it is something that she has also stated in her statement. Mr. Pinar, you may continue, and if there are any issues of postponement, we can deal with that at a later stage. Continue.
May it please the court, my lady.
Let's court,
Yeah.
please.
Now, Ms. Jacobus, you made reference, you used the word employees were antagonistic. Do you recollect that?
Yes, Council.
Now, the level, could you give an indication what was the level of antagonism that you experienced? Or how did it feel to you? How did you experience it?
Council, I felt the employees regarded me as a threat and I'm interfering. And that, I think, was the main thing that obstructed me supporting them, that there's no that I couldn't communicate with them. And that led to after my full observation towards the end of that week, where I called Dr. Manamela. I informed her that I've been around a few times, observing what is going on, and I have some concerns and I feel worried about the NGO. And that is how Dr. Manamela has set up the meeting, and they came through to support me.
Now, Ms. Jacobus, just to complete this, were you ever threatened at any time?
No, Council.
Then I just want to proceed to a further matter. In cross-examination, it was put to you, if I remember correctly, specifically Ms. Foster, but also maybe by some of the other learned colleagues, that you were subjected to a disciplinary inquiry. Is that correct?
Yes, Council.
And was that a departmental disciplinary inquiry?
Yes, Council. After the life marathon.
If you say after, you mean after Project Marathon,
Yes,
after the 30th of June.
Excuse me, Council.
Sorry, I say after Project Marathon, after the 30th of June 2016.
Yes, after that, it was contained in the Ombuds's report.
Good.
One of his recommendations.
Now, Ms. Jacobus, were you ever subjected to a disciplinary inquiry by the South African Nursing Council?
No, Council.
Now, the disciplinary inquiry you were subjected to by the Gauteng Department of Health, was a sanction ever handed down against you?
It was a 6 months administrative disciplinary where it was put on my record, on my file, and after 6 months it was removed.
What was it that was for 6 months? We don't understand your evidence. What did they say? What was the sanction ultimately?
The sanction was our participation within the Project Marathon, and that we did not escalate it up to higher levels of the department.
Ms. Jacobus, is that what the charge was that was put to you?
Yes, Council.
Now, if I refer to sanction, I'm wondering what I'm trying to get at. Were you convicted and found guilty, if I can call it such, or what was the situation?
No, I wasn't found guilty. It's just because of our participation and that we did not escalate. And we, according to the arbitration recommendation, we participated with the marathon project.
It's still not clear. She can clear it.
So it was taking all of that into consideration, Mr. Jacobus, but did the inquiry say, Ms. Jacobus?
Mr. Late? There is an objection.
Support, please, my lady. Yes, it's funny for me to object against the re-examination of the client, but it's again about relevance. The relevance of a disciplinary hearing in this matter is totally zero. Whatever they have found cannot have any bearing on findings of this court. It's just a waste of time to now go to the disciplinary hearing. That's what is made.
Thank you, Mr. Pienaar. Mr. Late, Mr. Pienaar, in reply. Your response to this? You are on mute, Mr. Pienaar.
To a certain extent, I agree with Mr.
Just a second. Mr. Late, your hand is still up. If you can just put it down, unless if you want to say something, thank you. Continue.
Milady, to a certain extent, I agree with the submission.
Just a second. The hand is still up. Yes, thank you. Proceed.
Right, please, the court, milady. To a certain extent, I agree with Mr. Late's objection, but the fact is, this was an issue that was put in cross-examination to Ms. Jacobus and left hanging in the air, if I can call it as such.
Was it not? Okay, continue.
And I'm not trying to infer with re-examination that it's specifically relevant to the final adjudication in this inquest, my lady. I just wanted to clear up any misconception that there may have been, specifically whether there was, let's call it a conviction, okay, and whether there was a sanction. If the answer is no, that's final, and that's a conclusive answer, my lady. That's all.
Okay, Mr. Pienaar. Mr. Late, not Mr. Pienaar.
But during the cross-examination, the witness already explained what the sanction was, and because it's, as my learned friend so readily intimate, it is a collateral issue, because it doesn't go to the heart or any of the facta probanda or facta probantia of this matter. She already answered that question, and it's not necessary to go further into the matter because of the fact that it is a collateral issue.
Thank you very much. Thank you. Miss, just put your hand down.
I'm trying my best.
Okay. Yeah, well, I'll just ignore it. On the basis of the proceedings in this matter and the issues that the court will have to look at, I don't think this question it's necessary. It is therefore not allowed. Continue.
May it please the court, my lady. Sorry, my lady, I just want to ensure. If your ladyship would just bear with me for a minute. May it please the court, my lady. I am of the opinion I've dealt with the matters I opined would require elucidation in re-examination. Therefore, this concludes my re-examination of the witness, Ms. Jacobus. Lady.
Thank you. If I may find out, Mr. Pitlela, do you still want to deal with the issue that you are raising so that we can all deal with it now, or do you want to file a proper application, a substantive application?
My lady, I'm gonna deal with my application at this moment.
Okay, you may proceed.
My lady, when we came on record
Yes.
as the legal aid, I was required to represent 3 affected or 3 witnesses. The number has since increased.
Yes. To
I'm
4.
now requested to deal with 4. There is 1 application pending from
Yes.
Ms. Kekan, I believe. Is it Matlakan? Yes. Now, my lady, I'm the only person who has been assigned to deal with this matter from legal aid. I have a record of over 37 documents that
You
I
are
need
not
to get through.
audible. I don't know what is the problem. Yes.
There is on record about 37,000 documents.
Yes.
Witnesses have already testified, and those witnesses were not cross-examined by my clients, as we had not yet been on record. Now, it will be remiss of me to insist on continuing with this matter and to keep trying to perform an exercise of catching up, because clearly I stand at a great disadvantage, especially with regard to the things that have transpired in these proceedings at the beginning. Now, this application I would have ideally brought at the beginning of the proceedings, but I agreed on the assurances that we will be given a chance with regard to the issue of cross-examination, and I'd assume that the cross-examination will extend for a longer period in order to allow me an opportunity to catch up. But clearly, I am not in a position to confidently say to this honorable court that the interest of justice will be served for my clients. I'm not here merely to rubber stamp or to put appearances of having legal representation for my clients, because their lives and livelihoods are at stake. Now, I'm going to request this honorable court to take all these factors into consideration and grant me a postponement so that I can then try and catch up and be at par with all the other legal representatives who have been on record for a longer period. It is impossible for me at this stage to continue to juggle and try and catch up, because I've been working around the clock, even on weekends, trying to study the records, trying to check for documents, and it has now become clear that to date I've only managed to get to about page 5,000, which means I still have 32,000 documents that I will need to process in order to be able to say that I'm ready to take on this matter. Now, it is my submission that the interest of justice in this matter demand that my clients receive proper legal representation. And in this instance, I cannot confidently say as an officer of the court that I'll be doing them justice if I'm not given the chance to acquaint myself with the record and to obtain even instructions from some of them, because I've only so far I've been able to meet with 2 of my clients, Ms. Noile and Ms. Karina Morale. I was unable to consult with Ms. Ethelyn Nube. I only managed to consult with Ms. Dorothy Franks over the telephone. So that is the extent to which I have tried to be accommodative of this process and to ensure that we do not become an impediment to its finalization. But with what has transpired today, it is very clear that we are acting at a disadvantage, and that is not in the interest of justice for my clients. Now, I'm going to request that these proceedings be postponed to allow us sufficient opportunity to consult with clients, to peruse the records, and then to be able to mount a defense and to advise our clients properly with regard to their rights as witnesses in this matter.
Thank you,
May
Mr.
please,
Pichel. Can I start with Mr.
Sorry, my lady. May I
Okay.
just interrupt at this stage? May the witness, Ms. Jacobus, be excused, my lady.
I don't see her. That is why I thought maybe.
Sorry, my lady.
Yes. Can we first excuse the witness so that we can now deal with the matter? Ms. Jacobus?
Yes, my lady.
For now, we thank you very much for your evidence. In case you could be recalled where there will be questions by, for example, Mr. Pichela, depending on the outcome of this, you will be advised to do so. For now, you are excused at the end of a re-examination by your representative. Thank you very much. Thank you. You are excused. Thank you.
May it please the court, my lady.
Thank you. Mr. Watbringle, do I start with you or Mr. Pina?
Milady, I'm happy for you to start with me. With great respect, Milady, we cannot have counsel for some of the parties at this stage of the game contending that because circumstances are not perfect, that this entire process must be postponed for 6 months. I understand that there is a wealth of documentation, and I understand that he's operating under less than ideal conditions. But just for example, my lady, in consulting with the clients that he does represent, it should be possible for him to circumscribe in relation to each of them which of the witnesses, whether it's a witness who has testified already, or whether it's a witness who is going to testify, is able to say anything that may relate to his clients. He should also enlist their assistance in looking at the documents on a calculated basis. Any real prejudice with respect can be dealt with by an application at a later stage to have a witness recalled if there's anything significant. And perhaps also our learned friend could enlist the assistance of the evidence leader, who might be able to provide a high-level guide as to which of the witnesses has potentially implicated any of these clients and how. So, my lady, the interests of justice simply do not permit of 100% perfect situation in relation to each individual who is potentially implicated, and I don't even know to what extent his clients are to that extent in the firing line. But assuming that they are, those are my submissions. We strongly oppose the application.
Then where is okay? Got it here.
My lady.
Miss Govender, yes. I was looking for my list. Yes, continue.
My lady, I believe that the issue that Mr. Patlela is raising today has been raised on a number of occasions. At one stage by Mr. Hoders and thereafter by Mr. Sibara. I sympathize with his position, and I sympathize with the fact that his clients are growing exponentially. It is a large record, and he obviously wants to represent his clients to the best of his ability. It's hugely inconvenient to the rest of the parties, but we would not want to advocate against his position, and we understand his argument from an interest of justice perspective, so we will abide the court's decision.
Thank you very much. Then it's Mr. Pina.
May it please the court, my lady. My lady, from the outset, we seriously object to a further postponement, specifically having regard to the length of time, 6 months, my lady. And I support the contentions and submissions made by Mr. Watt Pringle. It's my respectful submission that those objections are valid and fairly raised and presented to your ladyship. My lady, Mr. Pitlela is not the first counsel in this matter who's come in at a late stage. Certain of us, I remember, if I recollect, my ladyship, when I became involved during, if I remember correctly, when at the appearance in July of 2021, I was confronted with 30,000 odd pages of record and information. And there I concur with Mr. Watt Pringle, surely if a person knows what your client's case is, it does not mean every piece of documentation must be perused in the minutest detail. I mean, there's an arbitration that was conducted and which was comprehensive. That record is available. It's not extraordinary lengthy. There was an ombudsman report that was available from which a lot of information can be gleaned reflecting on a party's client, my lady. And nonetheless, endeavours were made for the matter to proceed because, and there I would also want to stress the point, my lady, it's in the interest of justice that this inquest proceeds as expeditiously as possible under the circumstances. And my lady, a request has now been made to your ladyship, not a request, an application for a lengthy postponement of 6 months. My lady, it's trite. Your ladyship has to exercise a discretion, such discretion to be exercised judicially, taking into consideration all these circumstances, my lady, and this, I refer to it as trite. And if we go back, I want to call it a locus classicus, is Rex versus Zaki, 1945 Appellate Division, page 505. And therefore, my lady, the only circumstances presented by our learned friend, Mr. Pitlela, to justify such a lengthy postponement is the voluminous nature of the record or of the papers, documentation involved. But nonetheless, my lady, if the exercise is conducted as submitted by Mr. Watt Pringle, then surely it curtails to a large extent, if not nearly altogether, the difficulties that Mr. Pitlela, our learned friend, may experience. At this stage, he has not presented your ladyship with a single instance of being prejudiced or having been disadvantaged, my lady. And once more, my lady, the question arises at the case management meeting that was conducted on the 28th of January of this year, 2022. Your ladyship specifically inquired, and if there had actually been a real disadvantage that could not be overcome, then that would have been an opportune moment to proceed with a formal application. That was not done, my lady. Now the proceedings have proceeded. And it's not just a case of, in the interest of justice, to present your client, but it's also in the interest of justice, my lady, that the inquest should continue and that all parties, notwithstanding the limitations they are subjected to, should take the necessary steps to get informed of what their client has to meet and what they have to conduct themselves with regard to. And in that sense, my lady, my submission is Section 16 of the Inquest Act 58 of 1959, as amended, is of importance. Because in every consultation I would submit with a client,
Have we lost him, Mr. Pinar? He seems to have frozen. Can only anybody assist Mr. Late?
I can't assist Mr. Pinar, he's not near me.
I'm just saying anybody can just phone him to check if he's aware that he has frozen.
I'll give him a call, my lady.
Okay, thank you.
He doesn't answer his phone, my lady.
But it appears he has left the meeting.
It appears so, yes.
Maybe somebody alerted him.
Right, please the court, my lady. Can you hear me now?
We can hear you, yeah. All right, but just
Sorry,
try to see. I don't know, yeah. Again?
We're subjected to load shedding and
okay, thank you.
Connection.
Okay.
A lady.
You may proceed. I think you have already covered a lot. I don't know whether you still want to add on what you have said.
Lady, yes. My closing submission, my lady, would be that it would not be proper, nor in the interest of justice, to postpone this matter for such a lengthy period of time, my lady, notwithstanding the difficulties my learned friend is experiencing, my lady. But if he follows the practice as submitted by Mr. Watt-Pringle, I believe there's no need for him to peruse and studiously peruse 37,000 pages of documentation, my lady. That can be limited to a very large extent, my lady.
Thank you very much, Mr. Pinar.
As such, my lady, my submission would be that this application for postponement should not be granted. Should your ladyship consider a postponement, my lady, I would venture to suggest it should not be more than a week at present, my lady.
Thank you very much.
May it please the court, my lady.
Thank you. Then it's who?
It will be me, my lady.
Stefan Bergen, yes.
Thank you, my lady. My lady, I must state at the outset that as one of the representatives in this matter, I have considerable sympathy for the plight of Mr. Phihlela.
Mm-hmm.
It is not easy to come into a matter in mid-journey, and especially not a matter of this nature where one is faced with the volume of paper that exists in it. My lady, but despite my sympathy, I submit one must look at the principles that our courts have on many occasions set out when applications for postponement are made. My learned friend, Mr. Pienaar, has referred to Rex versus Zaki. I wish to refer your ladyship to the decision of Meiburg, MYBURGH Transport versus Botha, trading as SA Truck Bodies, 1991, Volume 3, SA 310. My lady, it's a decision of the late and former Chief Justice, Mr. Mohammed, in the Namibian High Court when he was there. And the principles which were set out by him have been followed consistently in many decisions, also decisions of the Constitutional Court. And the starting point, my lady, is that a postponement is not there for the asking. It must be substantiated on acceptable grounds. Secondly, the trial judge has a discretion as to whether an application for postponement should be granted or refused, and that discretion must at all times be exercised judicially. It should not be exercised capriciously or upon any wrong principle, but for substantial reasons, and I mentally underline substantial reasons. Thirdly, an application for postponement must be made timeously, as soon as the circumstances which might justify an application become known to the applicant. The application for postponement must always be bona fide and not used simply as a tactical maneuver for the purpose of obtaining an advantage. And my lady, I wish to say in the same breath, I have no doubt that Mr. Phihlela's application is bona fide. And then the important ones, my lady, or the most important ones, considerations of prejudice will ordinarily constitute the dominant component of the total structure in terms of which the discretion of a court will be exercised. The court should weigh the prejudice which will be caused to the respondent in such an application, if the postponement is granted, against the prejudice which will be caused to the applicant if it is not. My lady, I would respectfully submit that the starting point in evaluating Mr. Phihlela's application is to go to the issue of relevance. Is the incident which Mr. Pienaar referred to in his re-examination of Ms. Jacobus, and in response to which Mr. Phihlela raised the issue of a postponement, relevant to any of the issues to be determined in terms of Section 16(2) of the Inquests Act? My lady, I submit it is not relevant. It is an ancillary issue. It demonstrates, I would submit at most, atmosphere, but it does not and will not, my lady, assist your ladyship in determining any of the aspects referred to in Section 16(2)(a) 2d. My lady, and what I'm going to say now must not be considered as criticism of Mr. Phihlela. Everyone has his or her own way of approaching a matter, but I would submit that when one is preparing to cross-examine a witness, the starting point would be to read the affidavits of that witness, if they are available, and if there is a transcript available of that witness's evidence, the transcript of that evidence. Had Mr. Pihlela done that, he would have noted in Exhibit H2 that the incident was dealt with in quite a degree of detail by Ms. Jacobus. My lady, I therefore submit that this is something that could and probably should have been to Mr. Pihlela's knowledge and should not have given rise to the situation that we have now. My lady, if the matter is not relevant, as I submit is the case, and if Mr. Pihlela could have apprised himself of the incident in question, as I submit he should and could have, then I submit there is no prejudice to him if his application is not granted. There will, however, be considerable prejudice to all the other remaining parties in this matter, and importantly, as also alluded to by Mr. Pinar, to the court and to the public. It will postpone the finalization of this matter greatly. It will be at great cost to a large number of the parties involved and their legal representatives who have set aside the time to give their full attention to this matter, which is time which will not easily be recouped with other work. My lady, the core, however, is this is not an issue, and when I say this, I refer to the incident which elicited the application, is not an issue which is relevant to the issues that your ladyship must determine. And in that context, my lady, I submit that the application should be refused. As your ladyship pleases.
Thank you. The representative for Ms. Section 27 and SADC. Ms. Power, are you there?
As it pleases the court, my lady. My lady, while we sympathize with Mr. Pihlela's position, we also strongly oppose the application for postponement, particularly one of that length. My lady, as Mr. van Bergen submitted, the considerations to be weighed are not only those of the implicated persons, but also of all the other parties that have been participating in this matter. We stress that Section 27 is a pro bono organization, is representing the 44 families on a pro bono basis, and this would be a considerable strain on the costs that have already gone into preparing this inquest. And so, my lady, it's also important to note that throughout this process, the parties who are represented by Mr. Pihlela were told to be in attendance to follow the proceedings so that they can be able to assist the legal representation once appointed. And I think we also align ourselves with the submissions made by SC Pringle-Watt in relation to how Mr. Pihlela's clients can assist him in better preparing. My lady, we add that given and now knowing the volume of work that's going into this, perhaps Mr. Pihlela and his clients can implore on the Law Society, the Legal Aid Society, to make available more resources. However, at this stage, we do not believe that a postponement is in order, and it will be very prejudicial to our clients. Thank you, my lady.
Then Ms. Mjerera. Ms. Mjerera.
Yes, please, the court, my lady. I support the application by Mr. Pihlela, taking into account the number of people that he is representing. He is currently representing 4 people, and he has indicated that there is a possibility of another person being represented by him as well. So I am of the view that it will be in the interest of justice that he be given the opportunity to prepare the defense of these people, though I do not agree with the period of postponement. That is the only issue that I have with his application for postponement. But otherwise, my lady, according to me, his application is with merits and it has basis, my lady. Yes, please, the court.
Thank you. You are followed by Miss Foster. Are you here, Miss Foster?
As the court pleases, my lady, I am present. My lady.
Yes, I'm listening.
I am in agreement with my colleagues opposing the application for a postponement. We must all just bear in mind that this is only an interim procedure. So after the finalization of this inquest, it must go back to the NPA and a prosecution or a decision must be taken.
You started, what did you say? Are you in favor of the application?
No, my lady. I'm opposing the application.
Yes.
And it will be in the best interest of justice that this interim procedure be finalized as quickly as possible. Due to the fact that after the finalization of this procedure, we must all bear in mind that even if this court does bring out a finding that somebody is responsible, it must still be go back to the NPA and a decision regarding prosecution must still be made. So in this regard, it's not in the interest of justice or in the best interest of the deceased families, as the court pleases.
Thank you.
Thank you, my lady.
Mr. Sibara, is it you or Mr.
It's me, my lady. Good morning.
All right. Thank you very much.
It's already in the afternoon. In fact, we are approaching lunchtime.
Well, it's always morning with us, isn't it?
It's always morning. My lady,
Yes.
I'm going to invite this court to honor its promise to the NGOs. I was sitting here assisting them to get representations.
Thank you.
This court undertook, and I'm going to quote, that I'm going to request you to sit and listen to the proceedings so that whomsoever is appointed to represent you will read the record, acclimatize himself or herself with the record, consult with you, then will be able to proceed. If there's a need to recall witnesses, he will be given the opportunity. I need to take my hat off to Mr. Pichel. When he came on board on the first day, he never interrupted proceedings. He said, let's proceed. Wherever I feel like I've reached the peak, I'm going to draw the court's attention. He managed to cross-examine effectively with very limited time he had. Now he's approaching this court that I have not even managed to finish my consultations. From where I'm sitting, I can't proceed any further. Is that not an officer of the court acting judiciously? He identified the best opportunity to bring this application. He did not come in the middle of cross-examination of Miss Anna Jacobas and say, stop. He waited for the cross-examination, re-examination to be completed, for the witness to have the best opportunity to be excused, and he brought the application. The only issue which I've got a problem a bit, my lady, is the duration of time. We were all given the opportunity to go and peruse. I'm quite saddened by some of the submissions of colleagues who were given the opportunity, who are opposing this application, because we were given the opportunity. I am the one who came here on the 23rd of July, before your ladyship, difficult as it was, and approached this court with a request for postponement. We were given over a month. And at that time, we were representing a person of interest. Parties came on board. I remember very well, Advocate Ramemela came on board, Ngobeni came on board, Munjelele came on board. Advocate Pinara, Advocate Shabangu. This court gave us the opportunity. Why can't that olive branch be extended to Mr. Pichela? He is representing more than 4 people. There's another one who is on the pipeline. it is going to be in the interest of justice, my lady, that he be given the opportunity to peruse the record. I am sitting here, my lady, because I'm representing a person of interest with Advocate Makan. I can put it on record today. I'm sitting on page 27,000, still perusing the transcript of the arbitration. I am still perusing the transcript of the arbitration. With regard to the ombudsman, I'm doing a catch-up game. So, my lady, you are muted. Okay, I can hear you. With the ombuds, I'm just giving a simple scenario. I'm doing a catch-up game. Mr. Pikela came in this matter in January. We are sitting on the first week of February. Can't we give him the opportunity to peruse? He's expected as well, my lady, to participate on the reduction and shortening of the proceedings, to make submissions. How can he make that submissions without knowing which direction is going? And it will be in the interest of justice, my lady, that he be given the opportunity, as it was promised to Miss Ethel Ngube. The day I raised it, she was following the proceedings at McDonald's. That she was promised that we're going to give you the opportunity. This is the opportunity which Mr. Pikela is requesting. And in my view, they must be given that opportunity. I am going, my lady, to abide by this court when it comes to the duration. But the postponement, my lady, this is what the NGOs were promised by this court. As it please the court, my lady.
Thank you. Thank you. Now, Mr. Hutamo. Yes, you are on mute. Mr. Hutamo, you are still muted. Still on mute.
As the court, please, my lady. Can her ladyship hear me?
Yes, we can.
We oppose the application on a limited basis. Firstly, we just want to emphasize that, like her ladyship, right at the beginning of the proceedings, when there were parties who were unrepresented, it was emphasized that all those parties had to be in attendance of the proceedings. And on that basis, from what Mr. Sibara had submitted, it was understood that the witnesses that Mr. Pikela is now representing are the ones who are supposed to give instructions on matters which had arisen during these proceedings. And as far as I understand, these proceedings are being recorded. So if it's an issue of Mr. Pikela wanting to familiarize himself with the record of these proceedings insofar as his clients are concerned, that should be done. But what we wanted to make a submission is that when Mr. Pikela joined the proceedings, it was indicated to him that like he had to take some time to familiarize himself with the proceedings so that like he can join in the proceedings when he is ready to do so. So he has not been prevented or like he has never been coerced or pushed to participate when he did not consider himself to be ready. Now that like the issue had arisen insofar as the matters that like he wants an opportunity to re-examine. Our submission in this regard is that for whatever issues that like he would like to raise, her ladyship had indicated that if a party makes a case that a particular witness has to be recalled for whatever reason, then that should be the approach that should be taken in order to ensure that the interests of all the parties are being considered. He should not be deprived of that opportunity. So if anything that we will support is that he will then have to make a case and set out the grounds why he wants an opportunity to cross-examine the witness once again. So once he has made that case and having considered the relevant parts of the record, we all know that there are a number of parties who are involved, but consideration should be given to those that like he is representing, because it will definitely not be each and every document in the record that he will have to go through in order like to prepare his questions insofar as the cross-examination of Ms. Jacobas is concerned. There are other parties or there are other documents which do not speak to the evidence of Ms. Jacobas. So all that like we can submit is that like he'll then have to make a case why the witness has to be recalled, and then on what issues will he want to be given an opportunity to cross-examine the witness. So it will be on that basis that like we will then oppose the application, and consideration should also be given to the resources. I know that submissions have been made. I do not want to necessarily regurgitate what like they have said. There are costs involved, and there is a need for the matter to come to finality. A period of 6 months is definitely quite very long and unreasonable, and it will not be in the interest of all the parties which are involved in these proceedings. So we will then oppose to what Mr. Pitlela had proposed insofar as the duration of the postponement. So whatever issues that like needs to be raised, they have to be highlighted, and he should then be given that opportunity to canvass matters that he thinks affect his clients.
Thank you very much.
Thank you.
Miss Siboko, are you there?
I am here, my lady. I hope you can hear me. I've been having serious technical issues with me.
I can.
Okay. Thank you, my lady.
Before you start, Mr. Hutamo, just put your hand down, please. Continue. I'll just ignore the hand.
Thank you very much, my lady. Whereas I sympathize with my colleague, Mr. Pitlela, in the invidious position he finds himself in, I do not think that a period of a 6-month stand down of the matter is reasonable under the circumstances. And I appreciate also the position of the client he is representing. And I agree with Mr. Sibara that from the outset, the court has been particularly interested and helpful to the NGO owners. And I also understand the position they find themselves in. One of my colleagues had said maybe the Legal Aid Board needed to supply Mr. Pitlela with further resources to assist. The unfortunate reality in the matter is that the reading is an ongoing process every day. Maybe my learned friend is going to have to bend the midnight oil, whereas I am not entirely opposed to him being granted an opportunity. I want to suggest maybe that the stand down is subject to your say so, my lady. He be allowed a few days, including the weekend, to catch up on some reading or read that which is particular and specific to his own clients, and then make a decision there. But 6 months is, without repeating what my other colleagues have said earlier, is unreasonable.
Thank you. Ms. Ramaimela or Ms. Mahlape, whoever is present. Are they here?
Good afternoon, my lady. Yes, we are here.
You seem to be quiet, yeah? That's why I can't even see you.
No, my lady, it's because we are of the opinion that you are proceeding with these proceedings very well, my lady. So we do not have any qualms with any issues. And as far as this issue is concerned, my lady, we sympathize with Mr. Pitlela as far as his application
is your camera not working? I can't see you, but I can.
I am trying to turn it on, my lady.
But proceed, it's fine. It's fine.
We sympathize with his application. However, we are also of the opinion that the length of time that he has requested is a bit unreasonable, my lady. If he can be given a few days, like Ms. Sibuku has indicated, as well as the weekends, and then we should resume as speedily as possible with the proceedings in order to curtail costs and to ensure that we reach finality, as it pleases the court, my lady.
Thank you very much. Ms. Koka? I don't know whether she's available.
I am available, my lady.
Okay, proceed.
My lady, our submissions are that, firstly, we applaud Mr. Phihlela to even be able to cross-examine yesterday. My lady, the reality is that the record is very long. I joined the proceedings last year towards the end of July, but to date I have not yet finished reading the record. Yes. In Mr. Phihlela's case, my lady, he is representing 4 NGOs, and yes, people died in those NGOs. While I have not counted the ones that died that have postmortems, my lady, which I believe are crucial for this case, I have managed to count how many people died at Tshepong. I hear he's representing Karina Morale. Plus minus 12 people died at Tshepong. And I also believe that he is representing Dorothy Franks.
Oh, yes, yes.
Of Anchor House, plus minus 7 people died in that NGO. At the Ngube of Precious Angels, about 21 people died there. And yes, Diane Noile of Siabadinga, about 8 people died there, my lady. My lady, I do support his application. However, my lady, the period of 6 months, it is too long. I would submit, my lady, that a week is reasonable for him to juggle as we have done. As I've indicated to date, my lady, I have not finished reading the record due to its volume, my lady.
But you have been continuing.
Yes, we are continuing, my lady. The application for a postponement on his part, I support, my lady. We do support, but the duration we do not support 6 months, my lady, as the court pleases. Thank you, my lady.
Ms. Maite?
May it please you, my lady. My lady, I sympathize and empathize with Mr. Phihlela, like as echoed by my colleagues. But my lady, the problem that we have here is the practicality of the situation. Indications have been stated that Mr. Phihlela should be looking at YouTube videos. He unfortunately only has 24 hours like the rest of us. We are all aware of the people that he is representing currently, my lady. And those people, my lady, as indicated by Ms. Kotla just now, in excess of 40 people passed away, which he's representing. There's going to be a direct and substantial recommendation if it's made by your ladyship, which would have a direct effect on these people that he is representing. So to merely say that perhaps a week would be sufficient, my lady, I would submit to your ladyship that that is not necessarily the right time and duration for which Mr. Phihlela would require to be able to acquaint himself not only with the instructions from his client, but as well as the arbitration record, as well as any other documentation that he has to acquaint himself with. I do understand and I do actually sympathize with the fact that there are families and it is in the interest of justice for this matter to proceed. And for that purpose, I do not think that 6 months would be a reasonable time measure for the postponement to take place, my lady. In respect of the time aspect that your ladyship deems reasonable, I would submit that we will abide by that decision. But to merely indicate that, unfortunately, the prejudices towards the other people except Mr. Phihlela, my lady, I unfortunately cannot align myself with those submissions that have been made. Under the circumstances, my lady, I will abide by the decision of the court.
Thank you.
May it please you.
Then, what is our time? I see it's 2 minutes past 1. I'm left with 1, 2, 3, 4, 5. Can we take the, do we finish with the submissions and then we take the lunch break? We allow Mr. Phihlela to.
My lady, I propose that if it's in order with the other colleagues, it's Sibara. Let's proceed and have our lunch thereafter.
And then, yes, there's somebody, I think there's a hand by Miss Beauty Kekan. I don't know what is it that, or is it Mr. Pichela? I don't know. Who's that?
No,
I saw there was a hand from Beauty Kekan. Was that a mistake or what? Mr. Pichela, I'm going to give you the chance, but I don't know. I just want everyone to finish addressing me. Unless if you've got something, but I don't want to disturb us. Can we finish everything and then we look into a matter? Can I ask you to put your hand down if you don't want to make submissions? Who's that? I'm going to proceed ignoring this hand if the person doesn't say anything. Yes, you are on mute, isn't it? Ms. Kekana, can we finish everything? We'll give you the chance after all the councils have addressed the court. Can you hear me? Please put your hand down. I just want these councils to. Do we agree that you make submissions, or do you want us to take the lunch adjournment and then the rest finish their submissions and then we allow Mr. Pichela to respond?
Lady, I suggest we carry on.
Okay.
I suggest we finish first and take the adjournment later.
All right. Thank you very much. I hope that is the feeling of everyone. Then there follows Mr. Shabangu, Miss Mboweni, Mr. Manamela. I'm told he's not here today, but there is somebody standing in on his behalf, and then Mr. Profi. Then after that, I'll go to the evidence leader. Then we take a lunch adjournment. Yes, Mr.
Shabangu.
Continue.
As a court, please, my lady, I do sympathize, my lady, with Mr. Pichela's position, my lady, and I further support his application, my lady. Looking at the number of the witness that he is representing, my lady, it will be fair and to the best interest of justice, my lady, that he be granted the postponement seat, my lady. However, my lady, the issue of duration, I'm on the court hand on that one, my lady. However, I don't support the issue of 6 months, my lady. That will be my submission, my lady.
Thank you. Then, Ms. Mboweni.
May it please the court, my lady. My lady, I align myself with the submissions made by my seniors, Mr. Watt Pringle, as well as that of Mr. Van Bergen. My lady, I do sympathize with Mr. Pichela. I understand that he has a lot to cover in a very short space of time. My concern, however, is that the postponement came as a result of a specific issue that needs to be addressed. So my submission would be that Mr. Pichela deal with that issue as it has arisen, instead of asking for 2 or 3 weeks or 6 months to be able to go and peruse the entire record again, or to peruse it, so as to be able to address certain aspects. I think that as we go along, I agree with my learned colleagues that we came on board, myself, last year, July, and we're still not finished with reading the record. So this is an ongoing process, and I think a bit of strategy might be required to enable him to be able to deal with issues as and when they arise. My lady, some of the owners of the NGOs has been listening to the proceedings, and they might also be of assistance where they deem it necessary to say that I heard this evidence being led and that is not my version. So, my lady, my submission would be that it would not be in the interest of justice and all the parties involved to postpone this matter for 6 months. Secondly, my lady, this is a public interest matter. And in as much as the public cannot be the main concern, they should be part of the concerns of the court, that this matter needs to be finalized. And for that reason, my submission is that he should focus on where the challenge lies, try to address that specific challenge, and we are then able to move forward with this matter instead of standing the matter down, because he will not be able to deal with all the aspects. I think the important thing is to deal with aspects as and when they arise, and that is what brought about this application. So that is my submission. I do not support the application for postponement. I believe that he should address the specific issue with his client and that we should be able to continue once he has been able to deal with this aspect, to be able to consult and get the advice of his client on the particular aspect. Those are my submissions, my lady.
Thank you very much. Mr. Manamela, I think somebody is standing in on his behalf. I don't know whether he will be able to address the court. Is there anybody standing in on his behalf? Nelisi, where are you here?
Yes, Judge, I'm still here.
Yes, I think.
Earlier,
did anybody show?
No, Judge, no one confirmed the appearance besides Mr. Manamela earlier on, Judge.
Mr. Profi, that's fine. Mr. Profi.
I just want to confirm before I proceed that my lady can hear me.
Yes, I can hear you.
My lady, I'm going to keep it as brief as possible. My lady, I don't think that my learned friend sympathy, he needs time. So I would be disingenuous to oppose his application because I sat in that very seat he was in when I joined the proceedings, dealing with an NGO, and I'm having to go through a record. So I agree that he absolutely needs time. I only have two issues with the submissions he's made is the time. 6 months is unreasonable, as we've all put forth that we are still going through the record, and so he doesn't need 6 months. And he might have 4 witnesses to answer for, but it's one record that he will go through in respect of all 4 of them. So he doesn't need that amount of time. My lady, I then just submit that, apologies. The aspect now, the issue of relevance comes into play. But even if we surpass that issue when we find that it's not relevant, we'll sit in this very position with the next witness, that he simply won't have the time to get up to speed for the next witness. So my submission is to give him at least a week and a bit to read through whatever he needs to read through.
I've noted you, Ms. Matlapi.
Take the relevant instruction that he needs so that we put this matter to bed. We never hear of it again. He would have then had the time he needs to catch up, and he can then, this witness can start when we come again. He can settle this issue, this incident that had happened, and we can put to bed the preparation time that he needs, and we can proceed smoothly from there on. My only concern is that if we don't give him the time and we rule on this that it's not relevant, it will come up again, because he sits here with us from 10 till 4, and then he has to go home and prepare. The same indulgence the court gave Bushlebe Nkosi in terms of postponement to get legal representation and to give me time to get ready and consult.
How much time were you given?
I had 2 weeks to get ready, so, and I was ready to proceed. I just found myself in a position where the court was in a postponement, whereas he doesn't, and that's not his fault. So yes. The very same way I got on board in 2 weeks is the same way he can. So his predicament is valid.
Can I hear Ms. Matlapi? I saw you raised your hand.
Indeed so, my lady. I realized that when I made my submissions earlier on, I indicated that he can be given a few days. That was a slip of a tongue, my lady. I would like to withdraw that. I will leave the time limit into your ladyship's capable hands, my lady, as the court pleases.
Thank you very much. And now, the evidence leaders, Mr. Late.
As the court pleases, my lady. I will also parrot my learned friends that I sympathize with the situation of my learned friends.
Do you have a problem with your camera? I can't see you, I just hear the voice, but if that is the case, you may just continue.
My camera is on. I don't know why your ladyship is not seeing me, but I also had problems with seeing some of the other people on in the matter. From the start, I have indicated that the evidence up till now haven't implicated any of Mr. Pitlela's clients regarding the findings that this court has to make at the end of the matter. Also, I agree with Mr. van Bergen that the issue that now raised this matter is not relevant to the findings that this court has to make. The next witness, Dr. Lenkwani, does have a few things to say about precious angels. And I believe my learned friend has to take a look at that and consult with his witnesses before cross-examining the witnesses. But my problem is that a long postponement is not in the interest of justice, and I believe that as the relevant evidence come to the fore, Mr. Pitlela can consult and go to the relevant documentation in that regard. It was also said by Mr. Watt Pringle that it's not necessary to peruse each and every fine aspect of every document that has been uploaded to case lines. I also already indicated when Mr. Pitlela started out that he can go to the summary of the facts and to the case docket alone, not necessarily to the whole, to everything. The case docket alone will already show him where the possible criminality might be found regarding his clients. There is sufficient information in there to assist him in this matter, and he can further prepare as the matter goes on. So in that regard, I do oppose the application for postponement.
Thank you. I'm going to suggest that we take the lunch adjournment. He will respond. He will reply when we resume, and then the court might then, as a result, give a ruling. Thank you very much.
If it pleases my lady, I am in a position to reply if it will assist.
You want to reply now? Okay, it's fine. Then
Yes.
you can reply, and then the court will take will give a ruling after the lunch. I think. Oh, my apologies, Ms. Kekana. Thank you for reminding me. Can I hear you, Ms. Kekana? You are muted, ma'am. You are muted. Now she's leaving. Miss Kekana? Okay, there she is. You are leaving again, Miss Kekana? Continue, please. Now we're going to have a problem here. Can we take the lunch adjournment, and then as she fixes, she sorts out her problem there? Ms. Kekana, are you ready now? We still can't hear you, and you don't seem to be muted, but we can't hear your voice. I'm going to propose that we take the lunch adjournment now. You try to sort out your connectivity problems, It's now 18 minutes past 1. Can we resume at 20 past 2? Please try to fix your things there, and then we will hear you when we resume. Thank you very much.
As the court pleases.
Court pleases, my lady.
May it please the court, my lady.
As the court please, my lady.
May it please the court, my lady.
As the court pleases, my lady.
reconvened. Miss Kekana, where are you? Miss Beauty Kekana, are you there? What happened to Mrs. Kekana now? Mr. Late? I don't know if it is possible to check.
During the adjournment, she was on the teams, and but it seems she doesn't know how to unmute herself. She came on and she spoke, but she was muted, and then she went out again, and then she come up again. I don't know what happened now with her.
But now I don't know what we because if we exclude her now, but in any event, she has also made an application for legal representation, but it's not. We don't know the results yet, ne?
That's correct, Maureen.
I'm not sure if between the.
May I suggest that in view of this is the extended arguments that are before your ladyship, that we proceed with the response by Mr.
Yes, but I didn't want Mr. Phihlela to reply before I hear what Ms. Kekana was going to say. And you can see that I took some time. Who's having her number? Nelly, yes.
I remember when the time of termination was approaching by Mr. Mapyanya. I used to have a number, but I'm looking on my phone. I can't find it. I'll try my best to get it now, my lady.
Please do, but
check in quickly.
I think what we'll do in the meantime, I'm going to listen to Mr. Phihlela because I'm just worried about the time. We must finish this today. Yes, you may do that. Nellyson, I don't know whether she's there.
Yes, Judge, I'm here.
Yes, can you check if you have the contact number of Ms. Kekana?
Judge, I tried calling her during the adjournment. I don't have her numbers. I requested her to send me the numbers. I also requested on the chat here on Teams that she please send her numbers, and she hasn't, Judge.
Yeah, you see things like this.
I'm busy calling her now.
Okay, you have her number.
Yes, madam.
Can I take just a 3-minute break so that you can call? We hear the.
She doesn't answer, my lady.
She doesn't answer.
Yeah. It's going to the voicemail, my lady.
Can we, in the meantime, listen to Mr. Phihlela? And I don't know, where is she watching the proceedings? From where is she doing this? Because it appears, I saw she was in uniform. Maybe she's still working.
Yeah, as far as I understand, she works at Mamelodi Hospital, if I'm not correct, mistaken.
But is it not possible if she's having challenges like this, why don't she come to one of your offices so that she can get assistance?
I don't know.
Until maybe she gets legal representation, maybe the representatives will advise her on what to do. But just for the purposes of this, I think what I should do before I give a ruling, will just also give her a hearing. Let us listen to what Mr. Phihlela is going to say, in case there is something that might come from Ms. Kekana, which will, I don't know whether maybe, Yes, Mr. Late, let me hear. Ah, there she is. There she is.
She is here. The witness has been sitting here since 1 o'clock, Ms. Dr. Lenkwane. May I excuse her and inform
Yes,
it that
please,
our
you
phoners
can excuse her.
will be there.
Yes, just excuse her. Let she be here tomorrow morning.
Okay, that's all, please.
Thank you. Miss Kekana. Good afternoon. I hope you are not going to have problems again, please. We still can't hear you. You are having some problems. We can't hear you. And you don't appear to be on mute. Mr. Late, did you forget to put your hand down? We can't hear anything. I don't know if other people can hear you. Something is wrong with the connection there. Is there anybody that could assist you there?
I can't hear my lady. We can't. I can't hear either.
We just see your mouth and your face. Mr. Late, just put your hand down, please, unless you want to address the court. Yeah, we're going to have a problem here. Mr. Pitlela, in the meantime, do you know how far is her application for legal aid?
Unfortunately, my lady, I haven't been informed of progress in that regard.
Can you please assist us? Because we are banking on you. You are here now, so we're going to hijack you to assist us. Mr. Sibara has been doing this for quite some time, and on behalf of all these clients of yours, so you'll have to assist us.
No, I'll make the relevant inquiries, my lady.
Yes. I can see Miss Pitlela wants to say something. Yeah. I just want to find out if she can be able to come to your offices tomorrow, Mr. Late.
I'm trying to get hold of her, my lady, but she doesn't
I think
answer.
maybe she forgot her phone on silent.
I'll ask the investigating officer also to contact her because it seems he's got immediate contact with her.
He has got?
He's got immediate contact with her. The last time I phoned him, he immediately contacted her.
Yes. Can arrangements be done that she comes to your offices tomorrow just for the purpose of this so that we can lay this to rest without any waste of time?
It can be done, my lady.
Because my problem is I don't want us to put her aside and not take her submissions into account. That's why I don't want Mr. Pitlela to respond to reply before she does that. She make her submissions.
Yes. As a court, please, madam.
Yeah, we're in a fix now. Let's just wait for her. If she comes, I'll just have to tell her to avail herself to your offices tomorrow, because I don't see us getting anywhere. Is it possible just to take a 5-minute adjournment, and then once she joins, then we can just connect those who have not connected?
I think it's better. Oh, she is, madam. She said.
Yes. Okay. Thank you. Miss Kekana, can you hear me? Yes, but you have got a problem. I'm going to request you. Yes, it's fine.
My lady, may I request that your ladyship should inquire from the witness, Ms. Beauty Kekana, when she made the application, because on the last occasion, we're still waiting for her to bring documents in which she's applying for legal aid assistance. And it appears that that wasn't done. I'm still waiting on a call that will inform me how far the
This is what is breaking the proceedings, you see? And this is what has been happening with your clients. All right, I'll deal with that. Thank you. Perhaps let me see what is happening. I'm going to, yeah, she can keeps on coming, going.
Good afternoon.
Thank you very much, ultimately. Ms. Kekana, how are you? If I can, your problem is, so the camera is a problem now.
Pula e ka speed. Pula e.
No, pero puede.
Ira ka pela. Ase nna ke yona mola e itimile.
Don't confuse her, please. Ms. Kekana? Can you hear me?
Yes, I'm trying to. She's trying to connect me.
You are already connected. The problem is the camera.
Yeah, he's trying to correct the camera.
Okay.
Okay. Thank you. Good afternoon, my lady.
Thank you very much.
Good afternoon, my lady.
Good afternoon.
Can you hear me?
Yes, I can hear you now. Yes, just relax. Just relax. I can hear you now.
My lady, my submission.
Just a second. Before you pick up other problems, should you pick up problems now, I'm going to request you that tomorrow you avail yourself at the evidence leader's offices. You'll have to talk to him so that you can address the court in case you can't do it now.
Okay, my lady.
And then, okay, continue.
My submission to you is that NGOs have no legal background, that they can assist Mr. Phihlela as indicated by some of the councillors. The other thing is Mr. Phihlela finds himself representing more than 4 as compared to other councillors. Therefore, for the interest of the justice, my lady, Mr. Phihlela's submission should be granted, but the court should decide on the time frame.
Okay.
Otherwise,
if you say more than 4, are you counting yourself? Because
I'm counting myself.
How far is your application? Have you just a second? Have you submitted your application?
Last week, I found that their offices were closed because they knocked off earlier. So this morning I submitted.
Did you submit all the documents?
Yes.
That were requested?
Yes.
Okay. Thank you very much. Thank you very much. Mr. Phihlela, you may proceed.
Thank you, my lady. I can confirm that last week, Friday, there had to be fumigations in the office. So we closed offices around 1 o'clock.
Okay.
Yes. My lady, in reply, I just want to correct one thing, which I think it's a misnomer.
Okay.
When I made the formal application after the, my lady?
Yes, I'm listening.
Yes, when I made the formal application for a postponement, I did not indicate a period. The period I indicated when I raised an objection. So I just want to correct that, because the formal application, I never indicated any period or duration. I never said I want 6 months. That was said when I raised the objection, my lady. So I just wanted to correct that.
Okay.
Now, with regard to what was said by Advocate Pringle SC.
Yes.
My lady, the exercise that I had undertaken to date, and which has actually allowed me to be able to get through a lot of the documents, has involved exactly what has been suggested here. Because I had requested the witnesses, some of them, to give me an indication of the part of the testimony that is on record by Ms. Jacobas,
Yes.
which they were disagreeing with. Now, some of them have managed to provide me with those documents. I think the most important thing that was missed is the fact that I indicated at the beginning that I was only able to consult with 2 witnesses.
Come again?
So, leaving 2
You are not
witnesses who have not had the opportunity to consult.
I didn't pick
I'm
that
saying,
up. Yes.
yes, I'm saying I was able to consult with 2 witnesses.
Yes.
The third one, Ms. Dorothy Franks, because she came on record. I think I came on record for her last week. If I'm,
Yes.
I think this Monday. If I'm.
But she was previously. Yes. She was better off because she was previously represented. I'm just saying.
Unfortunately,
aware that she was previously represented. Okay, continue. That's fine.
Yes, I'm saying I haven't received anything from my previous counsels with regard to notes or anything of that nature. I wasn't even aware that she was previously. Yes, I was not even aware that she was previously legally represented. But my lady, let me outline the processes that I've followed to date. At the beginning, when I joined the proceedings, I received a link to the case line bundle on the 12th of January this year.
Yes.
That was at about 16:08 p.m. in the afternoon.
Yes.
Now, on the 13th, I addressed an email.
You say on the 12th?
Yes, 12th of January. Now, I was
you say in the afternoon at what time? Just a second.
8 minutes past 4.
Okay.
Yes. Now, my lady, I addressed an email to Advocate Late on the 13th of January, in which I indicated that I'm representing 3 individuals, Ms. Ethel Nube, Dan Noile, and Karina Morale. Now, this email was prompted by the fact that I could not get hold of Advocate Lake on the phone, on his number. So I decided I'm going to write him an email. I requested him to provide me with the following information. Because first I indicated to him the amount of the work that I have to go through. And I indicated that I might have to seek a postponement. Then I requested him to give me, indicate aspects of the case relevant to my clients, including but not limited to particulars and evidence against our clients and how he intends to approach the entire inquest process, duration of the inquest, sequence of calling witnesses, etc. Now, Advocate Lay did not reply to my email.
Okay.
The matter was scheduled to be heard on Monday the 16th. On the 17th.
The 17th, I think.
Was it the 17th?
Yes.
Because according to my email, the Monday, we started on a Monday, so.
The Monday was the 17th.
The Monday was the 16th, my lady.
I don't know which diary do you have, but according to my records, I just know I'm in front of my.
No, I'll defer to your latest diary, it's fine. The 16th January seems to have been a Sunday. Yeah, it's the 17th. So on the 17th.
I thought maybe I was operating in a different planet.
The 17th.
Yes. Continue.
Yes. So on the morning of the 17th at about 8:59, that's 1 minute to 9 a.m. in the morning, I got a call from Advocate Late. He assured me that no need to worry, you can just follow the proceedings. There's no need for you to go through the entirety of the record. You'll just listen as you go along. And that impression was also reinforced by the court when he told me, no, you just listen, and then you get an opportunity to cross-examine. So for now, just try and follow the proceedings.
Yes.
So I did that up until this stage when the necessity. So, my lady, one, the issue of prejudice is self-evident. I don't need to address the issue of prejudice substantively or separately. It's self-evident. If you cannot prepare for a matter because of things that are beyond your control, that is prejudicial to my client's interest. And I didn't think it's necessary for me to go into that. I thought logic would dictate, but hence the saying logic is not, common sense is not common. So on the issue of legal aid providing me with further resources, I think that emanates from a poor understanding of how legal aid works. Now, we are governed by legislation, my lady. In fact, I will place it on record that we do not do inquests at legal aid. This is an exception.
That we know, and that was the reason which delayed the applications.
Yes, this is an exception. So, in exceptional circumstances such as this,
thank you.
I'm actually a civil attorney, my lady. I'm not a criminal lawyer. So, this is an exceptional case. So, to simply say legal aid must provide further resources, I think it's simplistic, to say the least. With regard to the issue of relevance, my lady, I think if relevance was really an issue, then the counsels on record would have objected when that evidence was being led. It cannot be raised now when in re-examination, when somebody is saying, I object to this evidence because I need an opportunity to cross-examine on it, and then relevance now comes to the fore. In any event, the evidence was not relevant. So if evidence was not relevant, then why was it allowed on record? I asked this question rhetorically, of course, my lady, but it also disposes of that issue of relevance as well. Because then we would not be talking about this evidence to begin with. My lady will note that on the 28th, we dealt with a letter from Rick Martin Incorporated, which in paragraph 3.5 raised certain suggestions on how to curtail the proceedings.
Do you want us to discuss that? Unless if I don't want us to go into that, it's not on record now.
No, we are not going into it.
It's something that has been shelved for another process. I don't want it to be clouding the proceedings. We know about it. If you want to make a point,
I was merely referring to it to emphasize that even in my email, the information that I had requested actually correlates with part of the information that has been requested in that letter. Because it would have enabled me to better curtail the amount of work that was before me. And that information was never provided to me. It's actually a miracle that I was able to cross-examine at this stage, because I had to work around the clock. From the 12th, I've not had a break. I've been working, sleeping after midnight every night. So for somebody to say I need to find extra hours of work to burn the midnight oil, also it's very simplistic. There's not enough hours in a day for a human being to be able to do that. It doesn't help for me to work around the clock and then fall sick and then there's nobody to appear on this matter.
I hope you're not fighting with anybody, no?
No, I'm passionate, my lady. That's how I speak. It's not a reflection of my temperament. It's merely the passion. Yes. Without leaving anything out, I think I've covered, for the most part, what has been suggested. Now, as I've said, I've tried to get summaries from my clients, but they simply regurgitate what is in their statements. They were not able to identify this aspect which really triggered this application, because it's one aspect which I felt, if there might be, it's like a landmine, really. there might be hidden things that I don't know of, and that is what concerns me the most. What transpired before? To date, I haven't brought an application to cross-examine the witnesses that have come before, because I haven't even had the opportunity.
Is well aware of that.
Yes, I haven't had the opportunity to get to that to that determination. And what I'm asking from this court, obviously, as a matter of precedent, the court has already allowed others a little bit of time, although it's far from sufficient. As Advocate Barra said, he was given a month, and I believe he's representing only one party in these proceedings. So I'm representing 4. So obviously a month would not suffice. Now the amount of deceased persons that my witnesses or my clients are implicated in also requires me to go through all those post-mortem reports. And that is not a process that you can undertake without a proper understanding of the medical findings. So I'm not saying I want this period for me to go and rest. I'm saying give me an opportunity to at least get ahead of some of the work. I think I've tried to this level to be in the position that we are today.
And we thank
I'm just fearful. Yes, I'm just fearful that something will emerge and it will seem like I'm a crybaby, or I want to disturb the proceedings.
All right. Thank you.
So I think it is in the interest of justice, my lady, that I be granted this opportunity, this postponement.
Just before, yes, I would like to hear Mr. Late with regard to this letter that you allege has not been responded to.
Yeah, it's an email, my lady.
Yes, it's dated
the 13th of January, 2022 at 3:22 p.m.
Thank you.
PC late at npa.gov.za. Life Esidimeni Inquest.
Can I hear you, Mr. Late, on this?
My lady?
Yes.
My learned friend asked the following from me. The particulars and evidence against his clients, how I intend to approach the entire inquest process, the duration of the inquest, the sequence of calling the witnesses, etc. Now, I found him and I told him there is on case lines a sequential list of witnesses. So that has been answered, and he has been told that when we first convened on the 17th. I told him there's a summary of the evidence, also on case lines, which outline the case, the evidence. And I don't even want to use the word against, because it's not evidence against any of the clients. This is not a criminal case. Again,
it's fine. Let's not go there, Mr. Late. It's okay. Continue.
It's the evidence about the NGOs, and that is part of the case docket, and it's part of the summary of evidence that I've referred him to on case lines. I cannot tell him how long the inquest will proceed. How can I do that? How I approach the whole inquest process, that is clear. What more does he want me to answer him? Does he want me to feed him with a spoon or what? Because everything is before him in case lines. Everybody else had access to case lines. It was not necessary for me to feed them with anything. I don't know what answer he wanted, because everything was given verbally to him when we first convened.
Okay, thank you very much.
I don't know what criticism against me is about.
So you have responded? Or
Yes.
you spoke over the phone. That was not in
Yes,
a was it in a,
and we spoke at the convenience of at the convening of the inquest on the 17th of January.
okay.
We were told about everything.
Okay. Thank you.
Excuse me, Malaya. I agree. I did not respond to him per email, but I gave the reason on the 17th. I was ill. I didn't even know about the email. I had COVID-19. I didn't even know about the email on the 13th of January. I only became aware of that on the Sunday evening.
Okay. Mr. Pichela, just to reply only on this.
Yeah, so it confirms that I never got a reply on this. And as I indicated, Advocate Late phoned me at 1 minute to 9. In fact, I got a missed call and I phoned him back. And that's when he tells me I must go and look at case line and I'll find all those documents.
Okay.
That is not very helpful because in any event,
but we at least he consists to that. We understand that, yes.
Yes.
Okay.
For spoon feeding, I don't know what he's talking about.
Okay, no, that's fine. Is there anyone who would like to say anything in relation to this aspect? Because I thought I would only give Mr. Late and Mr. Pichela an opportunity because all the other issues have been sufficiently canvassed.
My lady, sorry, it's Advocate Sibara.
Yes, I'm listening. How can I miss you, Mr. Sibara?
I don't know. I don't know how possible is that, my lady. I mean, equally, I was given a month. I would propose that a period of a month is much reasonable for my colleague to grasp whatever he wants to do. That's my proposal.
Okay. Anybody else before I close this debate? Silence means consent. The court rules as follows. Before the court is an application for a postponement by Mr. Pichela, counsel for, well, I will call them interested persons because I don't see them on the list of, not all of them are included. Okay, I see Diana, Miss Diana Noile is in the list and Miss Morale. Yes, I'll just refer to them as the interested persons, namely Miss Ethel Ngube, Miss Kari, who is here as a representative or on behalf of Precious Angels, Miss Karina Morale, as a representative of Tsepong, Miss Dorothy Franks, on behalf of Enka, and Miss Diane Noile, on behalf of Siabadinga. The reason for the postponement is that counsel would like to go through the entire record of the proceedings. Well, factors that are in counsel's favor are the following. Firstly, he came late in the proceedings and he's representing quite a significant number of so-called witnesses or interested persons, as I have indicated. On the other hand, the court should take into account prejudice as a factor, whether to consider the postponement or whether to consider granting a postponement or not. Factors that do not favor counsel are the following. One, the fact that the request for a postponement was a reaction to an incident which to this court appeared to be peripheral. One would say that it was not in the plan of counsel to ask for a postponement. He was only reacting to a specific line of questioning. That means the application is not substantive or substantial. Secondly, this court has already explained to counsel about the options he has as he joined this the proceedings late. The court has already undertaken to make all witnesses who have testified available to counsel for purposes of cross-examination if such witnesses need to be recalled. Counsel has already cross-examined the previous witness, Ms. Hannah Jacobus, and he put the versions of the parties that he is representing to this previous witness. Now we hear that there was no proper consultation. There was consultation. That is why he was able to put that version of the parties he is representing to the witness. This court will not want to interfere or entertain issues whether the consultation was done properly or not. This is a matter between counsel and the parties he is representing. Because of the fact that this matter enjoys publicity, the reasons advanced for the postponement so far are not so substantial so that the court may grant a postponement. Because in the circumstances, counsel will have the right to cross-examine and recall all the witnesses he may wish to cross-examine at his convenient time. A postponement will cause undue delay. It will be prejudicial to the parties in these proceedings. As such, it cannot be justified. The court finds that it will be in the interest of justice not to grant a postponement, but to proceed with the proceedings. If counsel is not ready to cross-examine any witness going forward, the court will always grant him an indulgence until he is ready to proceed with the cross-examination of any witness, including those that have already testified. The application for a postponement by Mr. Pitlela is therefore turned down. Thank you.
This court pleases, my lady.
As the court pleases.
We have already excused that witness, so it means we'll have to proceed tomorrow morning with the next witness. I'm going to request even the other colleagues, wherever it is necessary, to assist counsel, especially those who are also representing the NGOs, as to how to approach this record. On that note, the proceedings are adjourned until tomorrow morning. Thank you very much.
May it please the court, my lady, may I request an indulgence, my lady? We had to respond by memorandum to your ladyship at close of business today on the discussions we had on the 28th in response to the letter received from Mr. van Bergen's attorney, my ladyship. Further documents have now become or been presented. I've received them. May I have the indulgence of handing in my memorandum tomorrow morning, or not later than 12 o'clock tomorrow, my lady?
Yeah. When will I have time to go through them? Okay. Is that the feeling of the others who have not yet submitted? Can we agree about tomorrow, 10 o'clock? Because all of us will be sitting in the proceedings tomorrow.
May it please the court, my lord. I have, my lady, sorry. I have
I'm
no
not so
objection.
sure about the others, but can we, those who still want to make their own submissions, can we agree about 10 o'clock tomorrow for the submission?
My lady, we're going to abide by the court decision.
Okay.
We are not going to submit.
It's not for, if you don't want to submit anything, it's okay. Okay, thank you. Mr. Phihlela, I saw your face.
Oh, no, my lady, I was also want to indicate that I will not be participating in that exercise.
Okay, all right.
So please.
Thank you very much. Thank you for your time. The court is therefore adjourned until tomorrow morning, the 3rd of February 2022 at 10 o'clock. Thank you.
May it please the court, my lady.
Court pleases.
Yes, the court pleases.